Okay. Good morning. The hearing board is in session. Today is Thursday, January 5, 2017, and we're meeting in the hearing room at SCAQMD headquarters in Diamond Bar. Time is 9:10 a.m. We have one matter this morning, and that's SCAQMD versus Aircraft Heat Treating, Inc., Anaplex Corporation, and DOEs 1 through 100, case 6066-1. Who's representing the executive officer this morning?
William Wong and Kurt Weiss on behalf of the executive officer.
Thank you. And representing Anaplex.
Good morning, Mr. Chairman and board members. Good morning, Mr. Chairman and board members. William Thunderberg and Hanny Fangari for respondent Anaplex Corporation.
Thank you. Those who will be testifying this morning, please rise to be sworn in. Raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you very much. You may be seated. I'm going to ask the parties to make opening statements, and immediately after that, we will call on two public witnesses, Supervisor Janice Hahn and Dr. Cyrus Rangan from the LA County Department of Health, and then we'll proceed with the order of the day.
Mr. Chairman, members of the hearing board, this is Kurt Weiss, the SCAQMD General Counsel. I understand that we have a stipulation on a partial order for abatement in this proceeding. This proceeding, in the district's view, falls into three parts. There is the matter of a public nuisance created by equipment operating at the Anaplex facility. There is a contribution to that public nuisance created by hexavalent chromium on the roof of the Anaplex facility. And then finally, there are permitting issues that need to be addressed in an order for abatement. We have reached agreement on a stipulation as to the first of those matters, that being a stipulated order for abatement with regard to nuisance created by the equipment operating at the facility. And I would like at this time to provide the board with a copy of the stipulated order. If you could give me just a moment, Mr. Chairman, I have some document shuffling to do here.
We'll be off the record.
has this,
Yeah, I told you I'm going to submit that. It has the language.
no,
I'm explaining that our understanding
no, our
is,
understanding was
No,
that
no,
you
let me
offered,
let me
you
finish.
offered without the equipment list.
that's right.
Okay,
That's right. But our understanding is that that language triggers
I understand,
that
so this
list.
is,
And I told you I was going to submit that into the record.
okay, but this is submitted separately from this. This is an exhibit, correct? So,
Well, this is an exhibit to this. I don't care how it's addressed. If you want to clarify and I'm willing to clarify.
okay,
But those are two separate documents, but I'm putting on the record that our understanding is that it's that equipment that goes down if you exceed the 1 nanogram standard.
that's not what you said.
Well, I'm sorry, it is. Then I don't have it.
Shouldn't be surprised.
I'll share it with you.
Oh,
Yeah,
good.
I'll leave it here.
Is there another copy of this I can show the client?
Another copy?
Yeah.
No, this is the only copy I've got. You want another copy?
For the client, yeah.
It's, I can give you the aircraft order, which has the same, the relevant language is like that. Excuse me, Mr. Chair.
We're back on the record.
Will they probably have a copy of this stipulated order?
I do not know. We're about to find out.
Okay.
Mr. Funderburk has a question.
Yes, Mr. Chair, I just want an extra copy for the client.
Believe they're being made.
Mr. Chairman, Senator Holden raises a good point. We're going to need about 10 minutes to make copies of this. I apologize, I had not anticipated that we'd be stipulating this morning.
Thank you. We're off the record.
Happy New Year, my friend.
Thank you for that handsome.
You like that? Huh?
Yeah, that's great.
I apologize, Mr. Chairman,
Wait
that.
till we get back on the record. We're back on the record. Mr. Weiss?
Mr. Chairman, members of the board, I apologize. Apparently, the copying is taking a bit longer than I anticipated.
We're off the record.
This is aircrafts.
No, that's, oh, you want
This is aircraft, says aircraft.
yeah, but that should be in order for me against,
Oh, both of them.
both of them.
Do you happen to have aircrafts?
Let me see, I might have them in the file.
While we're waiting for the copies to be made, sure. While we're ready for the copies to be made, I've been advised that there is an overflow room for those members of the public who were unable to find seating. In the hearing room, it is CC6. And I think there's a person outside who can escort you to that facility, that room. We're off the record again. We're back on the record. Mr. Weiss.
Mr. Chairman, again, I apologize to the board and also to the members of the public who are here today for the delay. I've provided two documents, proposed findings and decisions for an order for abatement, a stipulation between the district and Anaplex with regard to the first issue I described, and that was operation of the equipment at the facility. That document, with regard to the trigger for Anaplex's shutdown, which is found on page 6 of the document in paragraph 1, that provision has identical language to that in the aircraft order for abatement. Because aircraft and Anaplex's operations are somewhat different, the order in both instances requires the facility to shut down equipment if a 1 nanogram chrome standard is exceeded. The order says that either company shall not operate any process or piece of equipment capable of generating hexavalent chrome emissions. The second document that I've provided is a list of equipment that the district understands would fall under that provision, namely that being equipment that's capable of emitting hexavalent chrome.
That concludes your opening?
Yes, Mr. Chairman.
Okay. The documents distributed by Mr. Weiss, the findings, proposed findings and decisions of the stipulated order will be marked as exhibit number 15 for petitioner. The list of, no, 15, that's for the petitioner. Petitioner started out at 1.
Petitioner as relates to aircraft and petitioner as relates to.
They're the same. The list of equipment will be marked as exhibit 16. Mr. Funderburk?
Not used to these mics. Mr. Chairman, distinguished hearing board members, thank you for your service that you've provided in hearing Anaplex. I think that ultimately, as Senator Holden said many times before the LA City Council, Anaplex's goal throughout this process the past 30 days is to do the right thing. And Anaplex is here today to communicate that to the hearing board so that the docket of the hearing board can be spent on other things and that Anaplex has come around to realizing this. Dr. Julia Lester, former district employee and Anaplex's, what would have been Anaplex's expert for this proceeding and risk assessment and toxicologist, or risk assessment and permitting expert, is going to be working with Anaplex. The levels have come down at Anaplex. Anaplex desires that even though the County of Los Angeles is not a party to this proceeding, because there is a separate action, court action that was commenced by the county and the district, that Anaplex desires that the county work in partnership and cooperation with Anaplex to continue to reduce its emissions. Anaplex also wants to thank Supervisor Janice Hahn for her leadership in bringing what was probably a surprise to Supervisor Hahn, sticking up for her constituents and bringing the issues to the continued attention, not just to the hearing board, but to Anaplex. So, in terms of the process today, Anaplex's CEO, Carmen Campbell, who was prepared to testify, is here. She has got to get back to the company, and I don't know if she's going to be needed. She's wasn't planning on testifying if an agreement was reached. The company has reached agreement with the district, and the company would also like to express the aspiration of looking forward to working with the district in cooperation on working through the permitting and other issues related to allowing Anaplex's 90% Latina employee-owned, stock purchased-owned company to continue operating while public health is protected. So again, thank you very much to the board for its consideration and indulgence of listening to Anaplex's various arguments that it advanced, and Anaplex realizes that the way to do the right thing is to agree to the aircraft stipulation and stipulated order with the site-specific changes that have been called out in what you have before you. And Anaplex looks forward to working with the district to get on the district side. So thank you very much again.
Thank you. Ms. Prusak.
Mr. Funderburk had mentioned that there is a CEO or what have you of Anaplex who is available to testify, and we'll need to hear from someone from Anaplex to explain the measures that are proposed as part of this order so that we can understand them more in depth and in detail. So
we have we have several people here, and I'd like to be able to dismiss some of the experts because, unlike Berkshire Hathaway and other large companies, Anaplex does not have resources to, if it can, it made this decision. I'd like to dismiss some of the experts. I'd like to be able to hold on to Dr. Lester and a gentleman by the name of Bernard Moore, who Anaplex has replaced its prior environmental consultant with, and who was on the board of the Metal Finishing Association and also is the OSHA monitor for the Hickson metal finishing site, and is very familiar with the Anaplex operations, and he's would really be the person called on to discuss the specific equipment.
May I add here, before the board dismisses any of their witnesses, as Mr. Weiss had mentioned, this is kind of a three-part case now, and we're resolving the first part, but that leaves the second and third part. The second part would be an issue that actually we were unaware of when we filed the petition, but involved recent sampling results from the roof showing very high levels of hexachrome. So we are going to bring on testimony regarding that. And then there are issues of the permitting violations, which we will also bring evidence to. So I don't know if any of these witnesses that Mr. Funderburk wants to dismiss are involved with that, but if they are, they may want to stick around. And along those thoughts, at the pre-hearing conference, I said with the district move, and it does so move to bifurcate the cases so that we can just handle this fairly well. We're going to bifurcate the nuisance provision out, except that the roof situation is a little bit contributing to the nuisance, but we'll have to deal with that separately. And then there's the permitting violation. So we would like to separate out at least most of the nuisance provisions so that we can enter the stipulated order for abatement regarding that.
May I respond to that, Mr. Chairman?
Quickly.
Okay. The Anaplex cleaned its roof, and it cleaned its roof 3 weeks ago. The district threatened a TRO right before the July 1st weekend based on the fact that Anaplex's roof still had material on it. The district backed down from that. I think that the district has been out there. The roof is clean, and if it's a matter of the measures that are going to be required, those can and should be included. But the district, the roof issue is what we believe to be something that once it was brought to, Anaplex's attention, it was dealt with. As to the penalties, we're not going to, it would be nice to just wrap things up right now if possible, but if we're not going to object to the continued phasing of this. Anaplex, as you have already heard, I mean, Anaplex has been working furiously in this case to get control of and make the emissions measures. All 26 measures, the 26 measures in this stipulated order have been implemented at Anaplex. And so I just wanted to respond to the roofing issue to make sure that it's assured that the fire department was out there yesterday.
Okay, I think that'll all come out in the testimony. At this point, I don't know who the witnesses are. At this early point in the hearing, I do not know if your witnesses will be needed, so I'm very reluctant to dismiss anyone at this point. We've heard the opening testimony statements, and I think I'll now call on our two public officials, Supervisor Janice Hahn. I don't know if your mic is on. Okay. Would you state your name, spell it, and indicate for the record that whether or not you took the oath?
Yes, my name is Janice Hahn, Janicehahn, and I participated in the oath earlier.
Thank you. You may proceed.
Good morning, distinguished members of the hearing board. Senator Holden, it's always great to be in your company. I know you have always cared about the public and what's in our best interest. It was exactly a month ago today that I was sworn in as a brand new member of the LA County Board of Supervisors. And my district includes the city of Paramount, and I made this issue, this chromium-6 crisis, a top priority for me the moment I took office. One of my first meetings was with our County Department of Public Health on this very issue, and one of my first public events that I attended was the AQMD Town Hall held in Paramount. Now, I know that, and I have great respect for Bill Funderburk and those certainly who have been working so hard to get this company in compliance, and I understand that there is an agreement that this company is willing to agree to today. So my comments may seem harsh, knowing that everyone has agreed to go forward and work together for the best interest of my community, but I feel like I need to say these things anyway. Test after test has shown that the Anaplex Corporation is the source of dangerous chromium-6 emissions that are poisoning the air that the local Paramount residents and Anaplex workers breathe every day. In the weeks since your last hearing board meeting, new lab results from samples of solid matter taken off the roof of Anaplex show chromium-6 levels as high as 75,000 parts per million. And while I know there's no official guidelines on chrom-6 levels in solid matter, the director of toxology at our County Department of Public Health, Cyrus Rangan, who's here today, said those levels, in his words, were eye-popping. There are only a handful of chemicals on Earth that are categorized as known human carcinogens. There are many chemicals that we suspect may cause cancer. There are others that we are almost positive cause cancer, but we know without a doubt that chromium-6 causes human cancer, and we know that the levels of chromium-6 coming from Anaplex emissions are too high. Today, your board will take action in the interest of the public's health and safety. And I understand that your board will decide or may decide to enter into this agreement, having Anaplex suspend operations only related to chromium-6 operations. However, I will say that I am still deeply concerned about the workers that work in this facility. And I met the CEO, Carmen, and we shook hands out in the hallway, and we both agreed to work together in the best interest of the workers and the community. And I know it's a community facility, and I know many of these workers come from the community, but I'm concerned about their health as well. And I will be asking my Department of County Health to connect any of the workers who may be interested in getting their blood tested to see what their exposure to this chromium-6 has been so far. But my urging of you today is that once you enter into this agreement, and I believe with all my heart that it is a good faith agreement on both sides, but I'm asking you that you must hold this company accountable. Because it is one thing to say you're willing to comply. It's one thing to say you want to be a good corporate citizen. It's one thing to say you're going to work to bring these chromium levels down. But the residents that I represent have told me that it has been going on for too long. And they have felt like there has been no responsibility or accountability from this company. So please hold them accountable. I won't be interested in amending this contract later on. I'm not interested in them coming back and asking for things to be amended or extended or given more grace period. I think we're done with that. I think my residents are done with that. And I want to make sure that the public health of my residents, that health is in your hands today. And that's your responsibility. And I appreciate you allowing me to testify. This is a serious problem. I'll tell you, I have pulled out all the stops so far. It was under my leadership that I had my county council go to court over the holidays to have a temporary restraining order. I wanted this company, frankly, I'll be honest, I wanted this company shut down immediately until we knew for sure that they were in compliance and these chromium levels have come down. The judge disagreed with that and said he felt like they were making all the efforts they needed to make to come into compliance, and that's why we're here today. And I will thank them and I will appreciate them, but at this point, it's only a piece of paper. And we must hold them accountable, and we can't allow for those chromium levels to go any higher. We can't let them make mistakes or errors because it's the public health that's at stake here today. So I look forward to working with you. I've been asked by the CEO, Carmen, to come and tour the facility and meet with the workers. And I said, when those chromium levels are down, I'll be willing to make that tour. But thank you very much, and I have faith that you will do the right thing today.
Thank you very much. Mr. Weiss, any questions for Supervisor Hahn?
No questions.
Mr. Funderburk,
None at all. Thank you, Madam Supervisor.
board members?
Supervisor Horn, you plan to stay around and listen to the testimony? Thank you.
Okay, the next speaker will be Cyrus Rangan, MD, for the Los Angeles County Department of Public Health. Mr. Rangan, how much time will you need?
About a minute and a half.
Very good.
Thank you, hearing board members. My name is Dr. Cyrus Rangan, medical toxicologist and director of toxicology and environmental assessment at LA County Public Health. I spoke here at the last hearing to express my concerns over the urgency of this matter, and I'd like to offer some further perspective on the health risks. Well, yes.
And also for the audio record, did you take the oath?
Yes, I did.
Thank you very much.
The health risks of hexavalent chromium are well documented, as the supervisor pointed out, and accepted within the scientific and medical communities. Hexavalent chromium is a well-known human carcinogen, and there are only a few chemicals in the world that we can say this about. Now, it generally takes several years of exposure in order to attain that cancer diagnosis in such a setting. And I won't pretend to convince you that there's a massive wave of cancer diagnoses floating around Paramount that are directly attributable to chromium. But if there were, we'd be acting too late anyway. In this case, it's the mere risk of cancer from these exposures, from this well-known human carcinogen, that should be enough to prompt the need for immediate action. If the health department, to offer an analogy, were notified about loose asbestos fibers in a school classroom, we would take action immediately. The students would be removed, the classroom would be shut down until the problem was abated. If a teacher suddenly decided to start smoking cigarettes in front of her kindergartners, which sounds rather ridiculous, but if that happened, swift action would be taken to stop the behavior at once, and that teacher would likely be disciplined or fired. In both of those cases, children are being exposed to known human carcinogens. They are not at risk for getting cancer tomorrow from these exposures, but I'm certain that I speak for everybody in this room that those immediate actions would be appropriate. Anaplex's continued resistance, or at least resistance up until now that I've learned that an agreement has been reached, in this matter is really no different from continuing to send your children into a classroom full of loose asbestos fibers, or where a teacher is smoking in front of them. I think we'd all agree that none of us would do that. So I hope that we can all agree that the urgency of this health issue is very concerning, not only to the health department, not only to the AQMD, but also to the public at large. And as the supervisor said, to the workers in that community as well. And I'm not only concerned about the workers at Anaplex, but the AQMD workers who are doing their investigative work to make sure that their exposures are kept at a minimum as well. And that the need for immediate action is necessary to protect the residents of the city of Paramount. Thank you.
Thank you. Mr. Weiss?
No questions.
Mr. Vandenberg?
No questions, Mr. Chair.
Board members? Senator?
Doctor, what's the standard for health that should be exceeded in order to cause a health risk? Is it 1 nanogram?
Well, I think the 1 nanogram per meter cubed that the AQMD has established as this goal standard is a great first step.
The AQMD or the other experts?
Well, no, I think that the standard is actually probably going to be lower than that. I think it's a good goal to establish immediately for now to make sure that these two companies get into compliance. Once we reach that level, we're going to need further testing around the facilities and in the community to determine what the levels are and determine if an increased
In
health
your
risk is still
opinion, would
present.
1 nanogram have an adverse effect on the health of the people in the area?
It still could. It still could. We'll have to wait until we get to that point, re-examine the air after that point has been reached, and
So
then
that's-
determine what those risks are.
Then, of course, if 1 nanogram could be questionable in terms of the safety factor, what about 3.3 nanograms?
Well, 3.3 would be higher than 1, so I would say that's not a goal that we should be attaining.
Is that acceptable to you, 3.3?
At this point, I would not find 3.3 acceptable. I'm perfectly happy with the 1 nanogram that the AQMD has established for their goal. Once we get to that point, we'll reevaluate.
What if 3.3 was part of the stipulated order of abatement?
I don't think it's reasonable in a point like this to go backwards. We're already established 1 nanogram per
That's
meter
in
cubed.
here. That's what's being proposed.
It's to my knowledge that we're proposing 1 nanogram per meter cubed for aircraft, and that's what we are hoping that Anaplex will agree to as well. So if it's any different from that, I'd love to be educated on that. But at this
Says
point,
that-
it's my understanding that it's 1 nanogram per meter cubed.
Then someone have explained to me then on page 6 what line 22 represents. No, you can. You don't have to do it, but yeah, you can.
Yeah, I'll have Ian McMillan. We kind of explained this at the aircraft
The
stipulated order.
doctor's here, yeah.
Right, and Ian can explain the purpose of the 3.3, which is only for the first 7 days.
Okay, he'll do that at the point in time that
Oh,
he's
very good.
testifying.
Okay.
Well, 3.3 is not acceptable, you're saying.
At this point, I would say no.
Thank you very much for your testimony.
Okay. No one else? Thank you very much.
Anybody answer this time, Mr. Chairman? Is it appropriate to say, explain what page 6 that Mr. Weiss referred to, line 22, as it follows on to chromium 6?
We have a
They
few,
allow 7 days, they allow them 7 days to reach this, and they can continue to operate if it does not exceed 3.3.
okay. We have a few housekeeping items to take care of, and then we're going to go to the witnesses who can clarify this. Ms. Prusak?
I heard Mr. Wong referring to the aircraft hearing, and I just want to remind the district that we bifurcated, so
correct.
everything needs to be
Right, redone. right.
redone.
Yeah.
Thank you. And also, the senator was not
Right,
present.
he wasn't present at the aircraft hearing. Thank you.
Okay. Mr. Weiss, your first witness.
I'm going to defer to Mr. Wong here.
Okay, I'm going to, As Mr. Weiss indicated, this will be the, I guess, part 2 of this trifurcated case now. And so we would probably, well, I'm trying to think whether it's better to go through the stipulated order that was agreed to, at least to answer.
I think that would be,
Okay, why don't we do that? And I'll certainly answer Mr. Holden's question. So I have Ian McMillan here.
Line 22, page 6.
Right, thank you very much. And Mr. McMillan, would you please state your name and explain your position with the district? Oh, okay, would you, Mr. Ian McMillan has not been sworn in yet.
raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Yes.
Yes, my name is Ian Macmillan, first name I-A-N, second name M-A-C-M-I-L-L-A-N. I'm a planning and rules manager here at the district.
Thank you, Mr. McMillan. And do you have a copy of the proposed stipulated order for abatement agreed to by the district and Anaplex?
Yes.
Would you please go through each of the paragraphs and particularly focus on the paragraph noted by Senator Holden and explain the meaning of that too?
Sure, and so I think fortunately the paragraph that was pointed out is the first paragraph, and that's a good place to start. What this first paragraph in the order states on page 6, it sets a limit at the monitor that we consider most representative of emissions from the facility, and it sets a limit of 1.0 nanograms per cubic meter when averaged over the 3 most recent samples collected. I think the question that came up is that at one piece of this paragraph refers to 3.3 nanograms per cubic meter, and that 3.3 nanograms is really only for the first 7-day period of this order. And the reason for that is that this order is not designed to be retroactive, to look at samples that were collected before this order is approved, assuming that it would be approved. And so it's only taking effect once the order is put into place and then moving forward. The reason 3.3 nanograms per cubic meter was selected was if one sample is 3.3 nanograms per cubic
I
meter.
understand your rationale and your explanation. You're saying,
Excuse me, let him finish
but I want him
his.
to read something to me as you go. I want to read that line, line 22, starting with line 21. Read it out loud, please.
Sure. So in the first 7 days that this order for abatement is in effect, Anaplex shall not operate any process or piece of equipment capable of generating chrome-6 emissions if a single sample exceeds 3.3 nanograms per cubic meter.
So that's greater than 1 nanogram.
For a single sample, correct.
That is correct. So that means that the area may be permeating to the limit of 3.3, and if it exceeds 3.3, then you cease to operate. Up to 3.3, you can continue to operate.
Only for that first 7-day period.
Then what?
Okay, we're going to get
Go ahead.
all out of order if I let every board member interrupt the testimony. Let's hear the testimony, and the way we normally do, give the respondent an opportunity to ask questions, and then the hearing board will ask questions. Ms. Prusak.
I lose my thoughts sometimes.
Well, may I suggest, as we did at the last hearing, that perhaps we go paragraph by paragraph and ask questions to follow? That was the way we did it last time, I recall.
I think
Let's
that's
do
an
it that way.
appropriate way to go.
Continuing on with this 3.3, so that applies for a single sample, and the reason the 3.3 was selected was that if over the first 3 samples, if one sample is 3.3 and the remaining 2 samples are 0, then the 3 sample average would be 1.0. And that would be consistent with everything else as far as the rest of this paragraph as a 1.0 nanogram per cubic meter threshold. If the values are above the 3.3, then there's no way they could get below 1.0. That is the rationale that was used for the language in this paragraph. But in effect, the level that is set for this monitor is a 1.0 nanogram per cubic meter threshold. And the rationale for that 1.0, I should explain what that rationale is. For the monitors that are located close to Anaplex, they are located approximately 500 feet from the closest residence. There's some residences up on Jefferson Street just to the northeast of the facility that are approximately 500 feet away and approximately in a downwind position. And what we had seen from other monitors in the area was that across 500 feet, there's approximately a 5-fold drop-off in concentrations. So a concentration of 1.0 nanograms per cubic meter, 500 feet away at the next monitor would be approximately 0.2 nanograms per cubic meter. And so what is so special about 0.2 nanograms per cubic meter? At that level, there is a approximate residential cancer risk of 100 per million. And that is utilizing the state EPA Office of Environmental Health Hazard Assessment, their methodology, and it's consistent with all district procedures as well for risk assessment. And so setting that 100 per million cancer risk, that is still will require more action from the facility. What this does is it provides a temporary level until other district rules and programs can come into effect and bring the risk down to appropriate levels. So for example, District Rule 1402, the AB 2588 Toxic Hotspots Program, that has an action level of 25 chances per million for a resident. And it has a significant risk level of 100 chances per million. There's different requirements based on the risk level. What this order would do would be to bring down the risk to 100 chances per million or 100 per million or less until Rule 1402 can go through its process and have the facility come all the way down below 25 per million. And that process has already begun, but we want to do something in the interim until that process can be complete. So that is why the thresholds are set the way they are. I think with that gets through paragraph 1.
May I ask questions on paragraph 1?
Mr. Funderburg?
Any questions of him? The only thing that I would say is that
You have a question, not a statement, a question. Question for the witness.
I'm
None?
yes, I have a question. The information that you testified, that was based on the aircraft order? Is that right?
There's very similar language, if not exactly the same language in the aircraft order for this paragraph.
Okay. Thank you.
Okay. Dr. Lerner, then Sandra?
For a document, if we could get it,
Oh.
frame questions.
Yes, that would be helpful.
I just wanted to ask, we received this, it was marked as Exhibit 14 in the aircraft, and it was extremely helpful for this board to understand both the location of these monitors, the location of Anaplex, the location of nearest residences, and the monitor results. Could we get that admitted, please?
Excuse me, Mr. Chair.
Mr. Funderburg?
Yes, what Board Member Presac pointed out, there are additional monitoring results since the aircraft that go all the way through December the 29th. But we actually have Windrose maps with a map that's similar to that. I don't know which one you want to use, but it goes all the way through. The monitoring results should say through December 29th.
I think she was asking for the map.
I'm asking for the map and the monitoring results, but at the appropriate time, monitoring results since then can absolutely be introduced. That would be helpful as well.
So at this moment, why don't we introduce previous Exhibit 14 for the aircraft case into the Anaplex case as the next exhibit?
Any objection, Mr. Funderburg?
No objection other than just a general I mean, if the matter is bifurcated, then there's a foundational issue if we're going to depend on things related to, so maybe we could stipulate to get objections out of the way on foundation grounds. This is supposed to be treated as a separate de novo matter. Oops. Jeez.
Is he raising objections to the exhibit?
I think he was offering to stipulate to the exhibit.
Oh,
Yes, I'm offering to stipulate to the exhibit, but I'm trying to, for judicial economy, I'm trying to streamline any further comment or objection related to references to the aircraft proceeding if we're treating it as a separate proceeding here.
right. The only reference is because we had introduced it in the aircraft case, so we're now reintroducing it into the Anaplex case.
Ms. Prussack.
I just want to make sure Mr. Funderburk has this exhibit.
No, I don't. Thank you.
Oh, yeah, do you have that? No. Mr. McMillan, for speech, can actually project it on so that Mr. Funderburk can observe while we get him a copy of the exhibit.
Satisfactory, Mr.?
Yes, Mr. Chair.
Mr. Chairman, some board members have some questions on the subject before we even get to that projection.
I apologize, I didn't mean to step over you, Senator. It's merely, you were not present at the aircraft, and the board was able to find this to be helpful background to understand the context of the entire order. And so it would be a good foundation to lay before.
I won't lose my thought.
I think the senator would like to ask his questions before he loses his train of thought.
Senator?
Mr. Miller, McMillan, you mentioned at 500 feet from the site of the plant, you would be anticipating some levels of 0.02 or 0.2?
0.2,
0.2.
if the level was 1.0 at the plant.
You anticipate?
That's from our observation of other monitoring stations in the area.
Okay, well, there've been some testing, and I'm looking at the first section 8 and looking at the results. And maybe you should look at that also. Those levels are pretty darn high.
What was he referring to?
Senator is referring to Exhibit 8.
Oh, Exhibit 8. Okay, that's. Oh, this is the source test report that Mike Garabay conducted.
And while you're looking, have you ever seen 0.0 in your monitoring device?
Typically, we do not see a 0.0 level. What we'll find is some level of background that is consistent with what we find throughout the basin, which is fairly low, maybe 0.05 approximately.
So even with these changes, what is the likelihood of them achieving 3.3? I mean, 0.0, 0.1, I mean.
So I think the question is, what is the likelihood of that they could actually get down to 0 on any day?
And even the acceptable level of 0.1, 1 point.
Of 1.0?
Yeah.
I think that's more of a question for the facility of whether they think they can achieve this level. I think this is a level that we have set to try to ensure public health as the district rules.
Well, that's
come
what
to
you're
mind.
stipulating to in this stipulated agreement. You're saying that these modifications, these guidelines, this training program is going to get us to that level. And there's no confidence you're going to do it in 7 days.
I think the confidence that we have is that if they exceed that level, they will be ordered to shut down until they can achieve that level. That's what this order is designed to do.
The testing plan is being approved by the district, submitted by Aeroplex, their testing plan, and therefore, they'll decide, they'll let you know whether or not they've reached those levels.
That is not correct, no.
Would you tell me what the correct is?
So the monitoring that is being conducted around this facility is being conducted solely by the district. We are collecting all the samples, we're analyzing it in our own lab, and we're interpreting the results by ourselves. We do take input from the facility if there is information they have that can help us interpret some of the data, and we will listen to it, but it doesn't mean we're going to do what they say. It is all of our data that we're doing.
What is the rationale for the district approving Aeroplex testing plan?
Okay. Maybe a little clarification when you're saying the testing plan. Are you talking about the sampling and analysis plan that is in paragraph 2?
It's in here, I don't know.
So in paragraph 2, there's a discussion of the sampling and analysis plan, and what this. I'll touch on this quickly now, understanding we might need to go back. But in the sampling and analysis plan, Anaplex, if it chooses to, can conduct its own sampling in addition to what the district is conducting. And if that information proves useful and is extra information that the district believes can shed some light on what our results are showing, then we will consider it. We just want to make sure that with this analysis plan that any data they collect would be done under following district procedures and methods. But ultimately, the data that we will use to determine any exceedance of the threshold of 1.0 will be based on the data the district collects.
Is it the expectation or agreement in the plan that Aeroplex will submit the results to the district for their consideration?
They can submit some supplemental information, yes.
Would it always be verified by the district's monitoring? Is that what you're saying?
Correct.
Okay, go ahead.
Dr. Lerner?
Just a small question for those of us who are not really familiar with the risk analysis. Is there a table that could be made available to us? Because we are going to look at other companies with the chromium problem in Paramount, that gives us an idea of the risk assessment in terms of parts per million and the risk of cancer. If there is a table that could be made available, we don't need it at this moment, but at some point, if we could do that, I think it would be enormously helpful and reassuring to ourselves and also the community, because they will have access to that table. I don't know of anything that has been published widely. Thank you.
Yeah, Dr. Lerner, Mr. McMillan has told me that he does have such a document. Of course, it's not with him at the moment, and we can retrieve that later and make that available to the hearing board.
That would be fine. There's no hurry, because we want to get through this, but I think it's going to be very helpful background for this particular matter at hand and also future matters. Thank you.
Ms. Brusek?
Mr. McMillan, can you introduce for us on the map where Anaplex is and which are the relevant monitors?
Okay. So on this map here, this is a map of the area in Paramount where the district has been focusing a lot of our monitoring efforts recently. What we see is that there's a number of circles here that are black and white with numbers inside of them. Each one of those circles corresponds to a location of a sampler where we're collecting samples for hexavalent chromium. What we see here in this corner where I'm pointing up above, this is Anaplex's facility. It's on the corner of Garfield and Madison. And we see that we have 3 monitors located immediately adjacent to them, monitors 13, 14, and 15. You move a little bit further downwind to the east is monitor 11. When I say downwind, typically winds blow from the west to the east. On this map, north is pointed up. And so we see that there are a number of monitors very close to this facility. Would you like me to keep going, a similar explanation that I did for the last one, or do you want me to stop and ask questions?
I would, but it's up to you. Yeah, and
Okay.
I'd especially like to know where you said 500 feet is the closest resident.
So the closest resident to Anaplex, so if Anaplex is here in this corner, the closest resident is a block up. Here, this is Jefferson Street, right along here. And there's some homes, you see it says Minnesota here in yellow, just west of Minnesota. There's a series of homes in there. And then actually just a little bit west of there on Jefferson Street would be the closest single-family home. And that is located approximately 500 feet from Anaplex. This 500-foot relationship that I've been describing is based on monitoring data at a couple of other sites, just a little bit farther downwind. And so if we look at monitors 8 and 7, that's about a 500-foot distance between those here, about there. Site 8 is located adjacent to Aerocraft, which is the other facility we've been discussing recently. And about 500 feet downwind of them is another set of single-family homes here very close to Site 7. What we had observed for the relationship between Sites 8 and Site 7 was an approximate 5-fold difference in concentration, that if it was a level of 5.0 nanograms per cubic meter at Site 8, you would get 1.0 nanograms per cubic meter at Site 7, and that ratio has some variability day to day, but it's held pretty close to that through time. So observing that relationship, what we did see was that we didn't believe that there were any sources necessarily between Site 8 and Site 7 that would materially contribute to Site 7. So that ratio we felt was representative of the dispersion or the what would happen to pollutants as they move into the atmosphere from a source and move downwind. And this kind of relationship is not unfamiliar with what we see for other kinds of sources. So we took that same relationship that we saw at another facility just a block away and applied that same principle here, saying, okay, about 500 feet away, and again, in sort of instead of just directly to the east, just a little bit to the northeast, we see homes about 500 feet, keep that same relationship of a 5-fold difference, and that's why we have that 1.0 threshold.
Let me ask you a question. You were talking about Rule 1402 and the 100 in a million threshold. Is that normally measured as you are here, measuring it here at the closest or the nearest receptor?
Yes, the 100 in a million would apply to either a worker or to a resident, and would be the maximum exposed worker or resident. In this particular case, residents, because of the nature of their exposure, have higher risks than workers at the same concentration. So, for example, a resident can include children, very young children. Cancer risks are thought to be much higher for the same level of exposure for children than they are for adults. Their bodies metabolize pollutants differently, and they have a longer exposure period just because they're younger. In addition, that there's a lot more time spent at home than there is at work, and so that because of these different exposures for people at a certain location, residents will have a higher risk at the same concentration. So even though there are workers closer to Anaplex than there are residents, the risk is still higher, largely for those residents downwind.
Going back to condition 1, can you either remind us, I can't recall, but at least state for the record, it says exceeds 1.0 nanograms of chromium-6 for the most recent 3 samples. How often are samples taken?
The sampling schedule is a 1 and 3 day sampling schedule, and so it's every 3 days we'll collect a sample.
So it could be 9 days before we have the average, or say there's a high reading. It could take a long time before it reaches the 1.
It's typically about a week, so day 1, day 4, day 7. And so on the 7th day, that would be a week's worth of data. There is, I should point out, there is going to be a small lag time. We discussed this at Aircraft as well, but there is a small lag time between when we actually collect a sample and the laboratory analysis required to go through and actually get the results. It's a matter of a couple of days typically.
Okay, thank you.
Dr. Lerner?
Yeah, just to be precise about it, the 3 samples are collected, they are analyzed as a group? In other words, you have, so that you have no inherent error in the measurement because there's no variability. All 3 are done, is that right? So on day 7, the 3rd one is collected. When is the turnaround time? What day after day 7 would you have the answer?
Sure. There's multiple questions you've asked there, and I can address some of them. I think if you're getting into some of the more detailed questions about laboratory procedures, I'd probably want to ask a different witness. But just in general, we are collecting samples and analyzing them as we collect them. So we don't wait to run a batch necessarily. We don't wait to have 3 samples and run all 3. This is a rolling average, and so every sample we're making a new determination about whether or not there's a rolling 3 sample average that exceeds the 1.0 threshold. Question regarding about how long does it take? It's typically a day or two. Sometimes it can be a little bit, maybe another day, depending on specific conditions. But it's typically about 2 days from when we collect a sample to when we actually have finalized results, where we would make a determination of a potential exceedance.
Ms. Berg?
And you probably mentioned this last time as well, but if you could just briefly review the rationale for 3-day average.
Sure. I think one of the challenges, and you heard this from Dr. Rangan earlier, is that cancer risk is typically more of a lifetime concern. Typically, we think about exposures as far as years to decades of exposure before we're thinking of getting elevated cancer risks. And in this particular case, when we're looking at these thresholds of 1.0 nanograms per cubic meter or 0.2 nanograms per cubic meter, we're making some assumptions that those are going to persist for perhaps 30 years for a residential exposure, which is a very long time. However, we recognize that there's probably been exposures in the past, and that a week would represent an ongoing, consistent level that is too high. And so what we've been looking at is, rather than just a single sample that might have a spurious result, say for example a single sample might be 1.01 or 1.05, and all the other samples are at 0.0 something, you say, well, there's a spurious sample that's important to note, maybe there's something happening that day and we will follow up on that information. But as far as actual exposure and contributing to an actual risk, longer term provides a more accurate answer as far as what we think the risk might be.
Thank you.
Mr. McMillan, perhaps I should have asked this question of Mr. Wong or Mr. Weiss. The proposed order we have before us, exhibit number 15, does it incorporate the changes that were made by this board to the aircraft order? Before we issued the order, there were a number of changes that were made to the order which were stipulated by the parties. While Mr. Wong is looking that up, I do have a couple of other questions for you. Do you know if the Aniplex operation is a 24/7 operation?
No, I'm probably not the right person to testify on that.
Thank you. On page 6, line 19, it speaks of the monitors that are most representative of Aniplex. That's a bit ambiguous. Is there someplace else where those are defined?
No, this is the same language that we used for aircraft. I think the reason we wanted to leave this a little loose, so for example, we have 2 monitors right now next to Aniplex, monitors 14 and 15, as well as monitor 13. What we have seen in the data that we've been collecting to date is that typically monitor 14 will be the highest, but not always. Sometimes monitor 15 will be the highest. They both are, we believe are, the higher levels that we're finding at both these monitors, we believe are due to Aniplex's operations, but they do different operations on different parts of their property, and one monitor might be a little higher depending on what's happening on one part of the property versus another part of the property on any given day. So we wanted to leave a little bit of looseness in here so that we can look at all of the data that's available.
Do you have some criteria to determine, to make that determination? Because I can envision if a reading that is unsatisfactory to respondent comes up, that the argument could be made, well, that's not representative.
Sure, and we recognize that is a concern. I think one of the things that's built into this order is a process to allow that discussion to occur, to allow us to notify the facility ahead of time, hey, here are what the results are, and we set up a conversation for that same day to say, let's go through all of the information the facility has, let's go through the information the district has so they can understand our logic and our reasoning. I think it will be a little hard to put very specific details on that in this order, just because conditions may change one way or the other, and I don't think we want to limit ourselves. We want to make the best scientific judgment that we can at the time, and we'll do that while working with the facility and letting them understand what our thinking is at the time. And I think what we would find is that if there was a debate with us every single time that information had been made, I can't speak to what would happen, but I imagine there's a possibility that it could come back before the hearing board or to ask for a request to change that process.
But there is a provision for that discussion or exchange to take place someplace in the proposed order?
Yes.
Okay. We'll get to that later on. Ms. Prusek?
I see a difference, though, between Aircraft and Aniplex. The way it was presented to us, Aircraft had one site-specific monitor that was relevant, just monitor 8. Here we're talking about 2, possibly 3, that are right next to Aniplex. And would it be unacceptable to the district to say if the average of the air monitoring results measured at any of the district monitors most represented? Because I would want to see all of them taken into account and not have this issue of, well, is that one? Is that one? They're all next to the facility and downwind.
I think. Give me 1 second, I'm sorry.
We're off the record.
Right, okay, I think let's make that clear.
Okay.
We're on the record.
I think just to try to make sure I understand what you're requesting here. So I think what you're saying is that we add in the word any into this first sentence about any monitor. I think there's, pardon me, as long as I think we keep the most representative Aniplex emissions, I think that part is okay. If we add in the word any, that should probably work. I think it's trying to make sure ultimately that we're capturing the emissions that are coming from this facility, right?
Mr. Federberg?
Yes, Mr. Chair, this is news to us. Every single communication that we've made has committed to a monitor, that being monitor 15. Spatially on the map that's been presented, it's much farther than it looks. Monitor 14 is at the corner of Garfield and Madison. Monitor 13 is across the street on Aniplex fronts, if you look at your map, Aniplex fronts Garfield, and then the corner is Madison. So across the street from Madison, on the next light pole over, 50 or 60 feet away, is the monitor 13. All the communications that we've had to try to settle this has been about monitor 15, and so it's a little surprising. I think Dr. Lester probably has some things that we would probably want to introduce in response to this, but we were under the stipulated abatement order is clear. It says, like,
Where are you reading?
Aniplex monitor, page 6, line 19, it's singular. So does that mean they get to pick and choose which way, depending on which way the wind's blowing? Now we have wind roses for every single monitoring day. that are based on the Long Beach station. We don't have the Met data for the immediate area, but it's concerning because I think the Anaplex had thought it was going to be 15.
So you don't stipulate to the addition of the word "any"?
Can
We're off the record.
can I talk? Mr. Chair,
We're back on the record.
yes, if it please the hearing board, Dr. Lester, in lieu of just going through legal back and forth in the spirit of cooperation, I'd like to just talk to the district now about this issue because her understanding, as was ours, we were talking about mantra 15. She's going to have to deal with the communication that if there's an exceedance over the 1 nanogram per meter cube standard, and that's not what she was expecting, but it doesn't mean it can't be worked out right away, right now.
Okay, there will likely be other proposed changes. So why don't we allow you to discuss those with the district during the lunch hour?
That's fine.
And may I just make a statement before you'll discuss that, but I just want to add to it that I'm looking on the other side of what we had as Exhibit 14, which is the monitoring data, and I'm looking not just at monitor 15, which has at times extremely high levels, but 14 as well had extremely high levels at certain points during the monitoring. And I would not be comfortable with an agreement, with a stipulated order that excludes a monitor that has high readings from the stipulations. So just to consider that when you discuss it with your expert.
Thank you. Let's go on. Any other questions? Senator?
Mr. McMillan, your equipment for testing the monitors, how often do they calibrate it?
I'm not going to be the right witness to answer that question.
But they are calibrated, to your knowledge, are they calibrated?
To my knowledge, yes, but any details, I'm not the right person to answer that.
Okay, next question you might be able to answer. How long, to your knowledge, has Anaplex had a problem with emitting chromium? In excess of that switch?
There's a number of lines of evidence that we have that there have been hexavalent chromium emissions from this facility. The most recent data that we have, obviously, is the monitoring, which began in, I guess, the October timeframe, late October timeframe. I think we don't think that's when chrome emissions started from the facility. I think we believe that there have been emissions for probably a substantial period of time before then.
How long have you worked for the district?
I've been here since 2010.
2010. So you have no knowledge how long this company has been in business?
I don't know that answer.
Okay. Well, the next question to you, since 2010, which is about 6, 7, almost going to 7 years, to your knowledge, have they had these kind of problem when you assigned the project?
I don't have any information to believe that they're operating any differently when the monitors first started than what they were doing, say, a few years ago.
Were they having excessive emission at that time, to your knowledge?
I don't have any reason to believe that they wouldn't have.
Did they were or they were not?
I don't have any reason to believe that they were operating any different or that the emissions were any different prior to the time that we started collecting
What's the
monitoring.
definition of different? I don't understand what you mean. Is it excessive or not excessive? Within the standard or not within the standard?
Yeah, I think the problem is the first time we detected these excess emissions was when we first started monitoring there. And we did not start monitoring 6 years ago, and so, but we have no reason they had changed their operations, so it's quite likely that those emissions may have occurred in the past, but we just have not monitored it. So we have no hard evidence.
So 6 years ago, you started monitoring?
No, not 6 years ago, just in October of 20.
Just in October? Well, has there ever been, to your knowledge, an stipulated order of abatement between the company, Anaplex, and your district?
To my knowledge, there has been no stipulated order of abatement between the two companies, between Anaplex and the district.
So since the Anaplex has been in operation, the district is like hands-off.
Well, I wouldn't say hands-off, because they do have other equipment which we inspect on a regular basis. The first time we learned of these hex chrome emissions is when we started monitoring that area, and it picked up and narrowed it down to Anaplex sometime in October and November of 2016.
26. Well, I just saw in one of these reports that they had a violation and a notice was issued in 2013.
Right. As I said, we have been inspecting this company. They have had notices of violations and notices of compliance.
Then once you were cited for having a notice of violation, what was action did the district take, if anything at all?
Well, unfortunately, actually, I don't know that. I'm not the person to talk about the past notices of violation.
I'm just trying to get to the standard practice and the procedures of the district as it relates to these violators. You're a lawyer, so you know what I mean by that.
You're talking about the enforcement practices?
Yeah.
Well, I guess we could, if you want, we have someone from enforcement could testify generally about our enforcement practices, but I'm not sure if it relates to this particular proceeding.
There was a notice of violation. Continue, I'll get to
Okay.
this.
I think what Senator is getting at is that, first of all, we understand that an order of abatement is prospective. We're here, what do we do? And we have before us a stipulation.
Right.
However, in order to fully understand the issue, I think the board wants to go back and see some of the history and determine for itself if this stipulated proposal for a stipulated order is sufficient. At the aircraft hearing, I asked for inspector to come forward. The only inspector that was available was the current inspector.
Right.
For that aircraft facility. Was not present in the room. He had to be hunted down, took a while. He was produced. But we were not able to determine any of the history because he had recently been appointed to that, recently been assigned to that facility. So we didn't get any prior history on aircraft. I think we want to hear a little bit of the history on Anaplex. Ms. Proussat.
I had a question I had forgotten for Mr. McMillan. You had mentioned the 1402 process, and you'd mentioned the 100 in a million level that you're going for as sort of the threshold to bring down to until those processes could go forward. How long about do you, I mean, I know you don't know specifically, but can you give us a ballpark of how long the 1402 process will take?
So that process has already started. The facility will be required to provide a health risk assessment and risk reduction plan to us in, I'm doing this, unfortunately from memory, a few months, probably about 6 months. They are also required to give us what we call an early action reduction plan within 3 months. So before the health risk assessment and the full risk reduction plan is provided, they need to give us this early action reduction plan for immediate steps that they can take. In addition to that, once the risk reduction plan is approved, the facility will have up to 2 years at most to implement that risk reduction plan, but the rule requires as quickly as feasible. And typically what we have seen in the past is that the full timeline allowed by the rule is not what is taken to actually implement a risk reduction plan.
And what is the level to which they are required under 1402 to reduce? Is it 10 in a million? Is it lower?
The thresholds in Rule 1402, the 10 in a million threshold that you refer to is for public notice. If a facility has risks above 10 in a million, they need to notify the public through letters and a public meeting. For risk reduction, that is 25 in a million.
Okay, so that's what they'll be ultimately, under the Rule 1402, they would be required to reduce to 25 in a million
That is
from
correct.
current levels. Okay. And just one other question, okay. Do you have any other data other than the magnitude of difference between monitors 8 and 7 and the approximate distance as to how much lower the risk is actually at the nearest resident from, say, I guess, monitor 15 to the nearest resident to Anaplex?
We currently don't have that information, but part of the Rule 1402 process I just mentioned will investigate that. And so the health risk assessment being conducted under Rule 1402 will give exactly those answers by using computer modeling and site-specific information to try to estimate what are the risks in the surrounding community, not just to those closest residents, but elsewhere. But that's again, several months away.
Has there been thought given to placing a monitor at that residence or near that residence?
Again, I'm probably not the right person to talk about our monitoring strategy.
Okay, thank you.
Mr. Chairman,
Senator?
in your book, Section 5. Real good information.
Senator is referring to Exhibit 5.
Excuse me, Mr. Chair. Do we have the exhibits?
Yeah, I think these were actually introduced when the case was joined together, so you should have a copy of those exhibits.
It says, talks about a notice of violation, and the data was collected July 2nd, 2013. They talk about the violations and no permits were issued, and it just goes on and on.
Right, let me just clarify. The notice of violation was actually served, and you can see on the bottom.
I see when it was served, and I wonder why it took so long to be served.
Well, and a lot of times when they detect these violations, they try to figure out when it first started. So that accounts for the earlier date.
He started and he put down date of violation. So therefore, it seemed like an inspector was there.
No, that's not true, because what happens is the inspector goes and then determines, based perhaps on past usage or whatever, that the violation may have started on that date.
No, this is misleading information to suggest that it goes back to 2013. I mean,
The violation.
That's guessing at it then.
Well, the inspector doesn't guess at it. He actually examines the
The inspector
records.
need to be here to answer the
Excuse
question.
me, Senator, would you let
Go ahead.
Mr. Wong finish his answer?
All right.
Yeah, the inspector, based upon his inspection, will try to ascertain when the violation first occurred. And that does not mean that an inspector was there at that date, but that with his examination of records and whatever, he believes the violation commenced at that time.
Okay, well, you think it would be a benefit to have the inspector in here to testify?
Well, actually, I believe he is here.
He's here?
Mr. Sultani?
Yes, Mr. Sultani is here.
We'd sure like to be able to talk to him, Mr. Chairman.
At the appropriate time, we'll ask. Okay, have we concluded paragraph 1? I think this is a good time for a short break. We'll take a 15-minute recess, reconvene at 10 after 11, and then I expect sometime 12 or later, we'll take our lunch recess. So we're in recess at the moment until 10 after 11. Yeah.
I have the feeling that I'm back in Hebrew school, my Orthodox Hebrew school, the one I used to play hooky from. Because you guys wanted to go over every word, and I think it's great, because it's very interesting to learn about this. You know, one time I asked, I forgot which case we were hearing, on something in the past. You guys, man,
Yeah, I'm sorry.
We are back on the record. Board members, I have 4 requests to speak cards from members of the public. Some of these are teachers, and our normal process is to hold the public testimony until the end of the day. If we allow interruptions in the process, becomes a real problem. However, they have requested to speak before lunch so that they can get back to their other obligations. There are 4 cards. I figure it'll take about 20 minutes. Board members, what's your pleasure? Shall we allow it or reserve it? Okay. I'll call on Lori Guillen.
Good morning, and due to traffic, I was not sworn in, so do you want to swear me in?
Anybody else will be testifying, hasn't been sworn in, please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
State your name, spell it, and indicate whether you took the oath just now.
I did take the oath. My name is Lori Guillen, Laurie. Last name is Guillen. And I hope to enlighten you on some of the questions that came up during this past hour. First of all, let me explain to you who I am. I am a lifelong resident in Paramount, and I actually grew up 1 block east of Anaplex, where you had the questions about the residents. I grew up there for 25 years. I then bought my own home in Paramount, about 2 miles away from that location off of Jefferson and Garfield. That's originally where I lived. I still live in Paramount now. I'm very familiar with Anaplex, and I'll tell you why. My mom still lives there. My son, who is a deputy sheriff, refuses to leave that area because he's not going to leave his grandma. So I visit my mom. I visit my son every day. I hear about the complaints. I've lived in that area, and I've seen people sick. They're sick, they're nauseous, they're lethargic. I mean, I could go on and on. We're talking about cancer-causing toxins. Yes, I've seen my community, my mom's neighbors across the street who are not smokers die horrible deaths of lung cancer. I could go on and on, but I have a lot to say. So if you have any questions of me after, I'll answer them. But as I said, I'm a lifelong resident of Paramount, and to say that I'm outraged is an understatement. My soul has been insulted, and that's not easy because I've been a police officer for 30 years, and I'm not thin-skinned, I'm thick-skinned, and I will tell you I have been insulted to the core, not just for me, but for my community that I stand here and represent. You guys asked a question, how long has the monitoring been going on? The monitoring only took effect in October when we found out about the hexavalent chromium. But I have my own videos where I followed my own nose. We talk about hexavalent chromium, it's odorless, I realize that. So what am I smelling? I'm smelling other emissions. Paramount has become the dumping ground for nefarious industry who cannot do business anywhere else. I have video recorded 24 hours. You asked a question if they operate 24 hours. Yes, they do. I have gone in, I have watched from afar. I am known as a rata. I don't know if you guys know what that is, but it means a rat, and I take pride in being a rat for my community because I am doing it not only for my community, but the people who live in Paramount and the people who actually work at Anaplex who cannot advocate for themselves. The dog and pony show, when they come up here and they say, I've worked there, I'm healthy, look beyond the nexus there. I'm a community member and I see it, and I have no conflict, and I'm telling you, people are sick. I urge Anaplex to do the right thing. Our community will not go away quietly. We will be the watchdogs for ourselves. We will seek assistance from government entities like SCAQMD and Janice Hahn's office, and I'm confident they're going to be there with us. However, if it takes us to picket, we'll pick it. If it takes us to bring media attention, we'll bring media attention, because this has gone on far too long. It didn't start in October. We've been making complaints well before that. We've gone to our city council, and because our community is predominantly Latino, when they raise their concerns, what did you say? I didn't understand what you said, do you? They've been laughed out. I've been a police officer for 30 years. I've raised 3 kids in that area. Even though I moved away, my kids were babysat by my mother and father who live 1 block east of Anaplex. I'm concerned for them. Both of my daughters are now pregnant. I'm afraid to bring their newborn children to visit my mom 1 block east of Anaplex. When we talk about nanograms, 1%, it's still dangerous. We can't make Anaplex go away. You probably don't have the authority to make them go away, but you can hold them to the highest restrictions possible. We are people. We are good people. I told you, I've been in law enforcement for my whole career. I raised a doctor, a lawyer, a deputy sheriff, right there 1 block east of that location. This is the face that we're talking about. And even if they're not doctors and they're not lawyers, their lives are no less significant than my family's. And I will be the watchdog, and I will advocate for my community, and we're not going away. We cannot let Anaplex stipulate and wash their hands and say, you know, we're going to abide by these rules. When this has been going on for so long, Anaplex has been on the top list of violators with the EPA, and they'd rather pay the fines than to do the right thing. They'd rather pay over $142,000 in fines. They hire darn good attorneys to represent them. Make them put the right regulations. Make them put the best available. Why do we have to live in the dumping ground? Why do we have to be collateral damage? You are in a position to advocate for us, to be the authority that we need at this point. And I am not a person to come up here and beg, but I'm just about there. We need you guys to do the right thing for this community.
Thank you.
And it starts with Anaplex, but it doesn't end there. We have, like I said, we're the dumping ground. Please do the right thing.
Thank you. I'd like to remind the audience that this is a legal proceeding. We don't abide by demonstrations. I know you're supporting the speaker, but please refrain from applause or any other indication of your support or lack thereof. Mr. Wong, any questions for the witness?
The only question I had, and I do thank you for coming, is how long,
Ms. Guillen, would you
yeah, sorry.
take the podium, please? And remain there until everybody's had an opportunity to ask questions.
I thought I was getting kicked off. I'll be glad to stay.
A question had been raised as to how long Anaplex has been operating, and you've lived there for a long time. Do you know how long Anaplex has been operating?
Well, I actually did a little renaissance on the break, and the owner is here, and she told me it became a company-based business in 2011 or 6, she said, but they have been there since 1968.
Thank you.
Mr. Funderburk,
No questions. Thank you for your testimony.
board members?
Yeah.
Ms. Byrd?
Just basic. You made some references, and I was wondering what the basis for them were. One, that there were some list of the EPA that you referred to. that
Correct. You
they
can
were-
look
What is that in reference to?
water waste.
Okay, wastewater.
And the way that they
Okay.
handle waste material is also a violation,
And
not just the
so-
water waste itself. So my confidence level is low because they have been on the worst offenders list for 5 years. And that's public knowledge if you look up the EPA and the companies that they have cited.
And so the reference to fines that you were talking about has to do with wastewater?
Yes.
Okay, thank you.
So that's why I explained that our confidence level is low when we're talking about waste product, byproduct. If they can't, or they choose not to dispose of that properly, how do we know that they're going to stop spewing the poison in the air, which is even a worse contaminant and more dangerous?
Thank you.
Senator?
Ma'am, you mentioned neighbors and friends. to
I'm
your
sorry,
your
repeat
knowledge.
that?
neighbors and friends dying of cancer?
Yes. I couldn't even begin to tell you. My mom's neighbor, where I grew up across the street, died of a violent lung cancer about 5 years ago. And it was her daughter that started getting our little coalition together. She was the one laughed at city council. We have had rare respiratory, CODP or COPD, I'm a little dyslexic, so I get those two letters mixed up, asthma. The teachers will testify that there's so many kids with respiratory issues. I could tell you I have had numerous uncles who have lived in that area who have died of rare cancers of the kidneys, brain cancers, and when they have asked the family, these are rare cancers, we always knew, but we never had the evidence until the AQMD said it's hexavalent chromium. We've tried, but we've never gotten any traction. We've been stomped on.
One final question. Did you ever file a complaint to AQMD for violations?
We have called
Starting when?
AQMD, and Lisa Lampin, who will be testifying, she can tell you that it dates back all the way to the early 2000s, 2013, 2012. Prior to even knowing about the AQMD, we would call City Hall. There's a horrible smell. Not always knowing who to call that. It was the AQMD that dealt with air. Not everybody knows what their resources are, so they'd call City Hall. And City Hall would say, oh, don't worry, we'll take care of it. City Hall would say, hey, stop. These companies bring in a lot of revenue for our community. We never had anywhere to go. We never had anyone to turn to.
Would you say the City Hall and the mayor and the council would say that? Well, they testified before us, so I just wanted to ask you the question.
Well, you made a statement. Can I elaborate? You said they testified before us. It was our mayor that stood up here, and you asked him, how did all these metal companies come in to Paramount? And he said, Kevin, he couldn't answer it. And he's our mayor.
Thank you.
Anyone else have any questions for Ms. Guillen? Thank you very much. Next speaker is Lisa Lapine, followed by Jose de Leon, followed by Michelle Lewis.
No, I have not been sworn in.
Raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Okay, so I am a teacher with Paramount.
Excuse me. State your name, spell it, and then confirm that you took the oath just now for our audio record.
Okay. My name is Lisa Lappin, Lisa, Lappin. I just took the oath and swore to God to tell the truth.
Thank you. You may proceed.
I'm a 20-year teacher with Paramount Unified School District. I worked for several years at Alondra School, which is on the periphery of Paramount, and had no concerns. I was not an environmental activist. I was not worried about, I didn't even think about teachers, staff, and principal to sign a petition, which we took to the superintendent, Dr. Verdugo, at the time, asking him to test our school to see if there were any environmental cause. Dr. Verdugo said he would. He partially tested our school, a few rooms, and the outdoor quad. And I took a leave of absence for a year. And during that time, I went with a parent to Communities for a Better Environment. She was very concerned because her son had a very rare form of cancer. Thyroid cancer in a child is unusual. And she told Communities for a Better Environment that she had watched each one of her son's teachers have cancer, and now her son. And so they called a lawyer from the district attorney's office. A case was open. To my knowledge, it's still open. They've been investigating Paramount ever since, and I've been trying to help as much as I can. I've made probably 65 to 75 or more calls to AQMD complaining of a metallic pungent odor wafting over Lincoln School while children are present. That led to an investigation of Carlton Forge in 2013. They were found to be responsible. They put pollution controls on voluntarily, I think to look good to the community. But Aerocraft, their sister company, did not, owned by the same company, Precision Cast Parts. Aniplex did not. When this was happening and the entire community received a letter from Carlton Forge that they would be a good neighbor, Aniplex and Aerocraft looked the other way and put no pollution controls on voluntarily. And so I am very concerned about their ability or willingness to follow through once the abatement order is over. And in 2015, the EPA announced an enforcement order related to 2011 Malrissa violation, which Lori Guillen mentioned. President Campbell of Aniplex publicly said, Aniplex pledges to explore new ways to be a beacon of environmental stewardship. This was a year ago. This is not what we have seen. I encourage AQMD to commit to permanent monitoring of this company, not until they have reached a certain level, not 2 years or 3 years, permanent. And the same with Aerocraft, and the same with Carlton Forge.
Thank you very much.
And
Your time is up.
oh, okay.
Thank you.
And
Wong.
can I just say one thing? I wish to thank AQMD for everything they've done for our community, and Janice Hahn.
Thank you. Mr. Wong?
No questions.
Mr. Vandenberg?
No questions.
Senator?
When did you start teaching there at Lincoln?
2010.
Oh, it was at that time you asked the principal to do a survey, is that correct?
Oh, I made a petition, and I believe that was I started in 2009, and then in 2010, at the end of the school year, I got the signatures for the petition, took it to Dr. Verdugo, and sent a letter to Dr. Rangan about my concerns as well. So didn't start calling AQMD, though, until a couple years later. Didn't know about AQMD.
What year did you start calling AQMD?
2013.
Thank you.
Ms. Byrd?
You were reading from a document. What was the document that you were reading from?
I took it off the internet. It's posted. If I get my iPad, I could tell you the exact post, but it's about an article saying that Aniplex was cited by the EPA, and they were fined $142,000. So at the time they agreed to this payment is when Ms. Campbell made this promise of environmental stewardship.
Okay, thank you.
Any other questions? Thank you very much for your testimony.
Thank you.
Mr. Jose de Leon, followed by Michelle Lewis, and then Sarah Patricia Vega. Can't quite read the last name.
Good morning. My name is Jose de Leon, Josedeleon. I want to say that I'm very concerned about the high levels of hexavalent chromium found in my community, because my 10-year-old daughter, she goes to Lincoln School, which is probably half a mile away from them. And I'm so concerned about that, because, kids, they are the future of this country, not just Paramount. The other thing I want to add, since I moved to Paramount, in 2002, I smell they're totally different. I didn't know who to contact until I had the opportunity to meet Ms. Lapping in 2012. And at that time, I didn't even know who to contact, but Finally, like on 2014, I think, then I heard about AQMD, and we start to report those others. Even I invite you to go. It can happen at any time, different smells, you know. It's not just Anaplex. There are more companies polluting and in a small city. That's all I have to say.
Thank you. Mr. Wong?
No questions.
Mr. Funderburg?
No questions, thank you.
Thank you very much. Michelle Lewis, followed by Sarah Patricia Vega. Can't read the last name.
Good afternoon, honorable board members. My name is Michelle Lewis, spelled Michelelewis. I have been sworn in. Thank you for this opportunity to speak on the issue of the abatement order for Anaplex Corporation. I came ready to give a speech kind of lashing out for their tactics that they've been using. I was happy to find out today that they're being a little bit more amicable. I would like to go on record as stating I'd like to see both Aerocraft and Anaplex continue to show good faith effort in working with the AQMD and the residents of Paramount by voluntarily placing the best available emissions controls on your facilities. I want to say thank you to Janice Hahn, the LA County Board of Supervisors, the LA County Public Health Department, and the AQMD and this board. I'm grateful for an organization like the AQMD in our community with the resources, knowledge, and manpower to take on this enormous task. This is no small task. I admit this process has taken far too long to get to this point, but it's time that we move forward now based on the science. As I stated previously on record, there's a serious problem in Paramount with zoning regulations. Poor zoning places residents and school children at risk of serious long-term health problems. But do not use that, Anaplex, as an escape for your responsibility to do what is right in this community. Now, I'm a kindergarten teacher, and even a 5-year-old is capable of understanding that just because you can do something doesn't mean you should. These delay tactics should stop. Again, as a kindergarten teacher, this is a basic rule of playing nice in the sandbox with others. If you make a mistake, you own up to it, you apologize for it, and you make it right. Do not mislead your employees into believing that the AQMD, Public Health Department, and residents of Paramount are trying to take away their jobs and hurt their families. If Anaplex shuts down, it will be because Anaplex refused to play by the rules. It is your responsibility to accept your role in this mess. Several Anaplex employees have testified on their health and how healthy they are, but according to the OSHA guidelines, the employer who exposes employees to chromium-6 is required to keep medical records of those employees for at least 30 years after they leave employment, and that comes from the OSHA guidelines. It's necessary to keep these records for extended periods of time according to OSHA because cancer can often not be detected until 20 or more years later. It's not necessarily how you feel today, although the high contamination numbers that were found on the roof would indicate there's an immediate concern as well. I find it ironic that we can have what is called a safe school zone in California to protect our students from firearms, drugs, tobacco, alcohol, or anything within 1,000 feet of a school. The legislature has seen fit to increase penalties in these safe school zones. But poor zoning plans in the city of Paramount and other nearby cities do not allow us to consider these a safe zone from toxins. That is a shame. Thank you.
Thank you. Mr. Wong?
No questions.
Mr. Funderburg?
No questions.
Thank you very much. Sarah Patricia Vega, looks like a whistle.
Sorry about the last name, it's super long. My name is Sarah Patricia Vega Hueso. Do you want me to spell the whole thing out?
Just the last one.
Okay, S-A-R-A, last name is H-U-E-Z-O. I want to thank you guys for having this meeting. It really means a lot. The reason I'm crying is because I'm angry and I feel frustrated. We've been dealing with this issue for so long. I'm a resident. I've been living there for over 20 years. I have children that go to Lincoln Elementary. They're here, as a matter of fact. And sometimes when the kids are coming out of school, we can smell the stuff in the air. And it just breaks my heart to see all these children breathing this poison. We call and we request AQMD to come out, and they've been super helpful. I mean, we can't thank them enough. Just like Supervisor Janice Hahn, we've gone to City Council before, and as a resident, I kind of feel like they've downplayed the situation. They've made it seem it's not as serious as some of our residents are, trying to raise awareness for everybody. I have logs of times that I've called, and it just continues. It continues, and all we want is clean air. We just want our children to be healthy and not have to worry about them getting cancer or having to deal with some type of disease because of the poison that's in the air. Air is universal. I think we should all be able to breathe clean air and not have to deal with this poison constantly. That's basically all I want to tell you guys. I am a resident. I smell it. I report it time and time again, and it needs to stop. And to Anaplex, all I need to say is, please, just put the filters in. We wouldn't even have this. We wouldn't be here right now if you just put the filters in. You would save yourself money on the fines, on hiring the lawyers, if you did what you're supposed to do. That's pretty much
Thank you.
all I want to say. Thank you very much.
Mr. Wong?
No questions.
Funderburg? Mr. Funderburg?
No questions, thank you.
Doctor, and then Senator. Doctor.
Oh, yes. In your family, has anybody had lung cancer?
Like I said, we've only been in Paramount for 20 years. Knock on wood, up to now, not that we know of.
Anybody in your neighborhood have lung cancer?
Up until now, I've been a stay-at-home mother. So most of the time I've been, I used to work in the fashion industry, so I've always been at work. So with my neighbors, I don't really know how many have or don't have cancer. So I wouldn't really be able to answer that for you. But I know that when we've been to other meetings, there's been residents that I believe are like in their 60s or 70s that have shown up with lists of 30 people in their neighborhood that have died of cancer.
Okay. One last question. How far do you live from the company?
So from this company, I live far away. But from the school, from Lincoln Elementary, I would say my house is right here and the gate is where you guys are. I literally just walk my children across the street. And when I pick them up, there's been times where we can smell it in the air and all the children are out. Or sometimes during recess, you can smell it.
One last question. Has there been a complaint filed about the smell as opposed to chromium-6 that you're aware of? Or are you aware of any coalition or group of people who have sought to file a complaint about the smell?
Just residents, lots of residents. Like I said, we've gone to City Council for this, and now what we're trying to do is just get each other's numbers and, inform each other.
Okay. To your knowledge, nobody or anybody has filed a complaint with the AQMD?
I have logs of when I've called in. I actually have logs on my phone that I can tell you about.
Okay. To your knowledge, did anybody from the AQMD come out and sample the air or speak to you about it?
Yes. I've been in contact with several AQMD workers, and they're very helpful, and they try to inform you as much as possible with, when they're out there, and the areas that they're monitoring and things like that.
Fine. Thank you very much for taking the time to bring you and your family. Appreciate that.
Thank you.
Senator has a question for
I have
you.
a couple of questions. When did you start reporting your complaints to the AQMD?
I wasn't aware there was an AQMD up until a couple months ago.
Oh, a couple of months.
I would say, I didn't, personally, and to be completely honest, I didn't even know they existed up until about August of this year.
That's a problem to be resolved.
Yeah.
My next question, you saying, when you've been complaining with AQMD, they've come out, the employees, and talked to you and explained what the situation has been?
Yes,
Very helpful.
very helpful.
Thank you.
Thank you very much. I appreciate it.
You told us that you detected an odor. How long ago did you start detecting the odor?
It's been, I can't even say how long ago. Like, lack of knowledge, basically. Something doesn't smell right, but up until, like I said, I knew AQMD existed, and I started going to the town hall meetings. That's when I realized, oh, wait, something that I'm smelling in the air is probably toxic. So up until I knew about AQMD, I didn't report it. I just, knew there was something in the air, but that was pretty much it. Yeah, it's been a while. It's been years.
Can you describe the odor?
Oh, yeah. Most of the time, it's a burnt metallic smell. Now, they say that chromium-6 doesn't smell like anything, but we smell something in the air. Other times, it could be a burnt plastic smell. So we don't know what it is, but, as soon as I smell it, I try to call, and I go indoors. I close all my windows. I don't let the children play outside in the yard or anything because I'm scared for them.
Thank you.
Thank you.
Okay. I have no more cards. Time is 11:45. I think this is a good point to break for lunch. We have a hand in the audience. Yes, ma'am.
I made one error in my testimony.
Would you come up? Tell us again your name.
Lisa Lappin.
Go ahead.
And I believe I began calling AQMD in 2012 when my student had leukemia in my room. And I began calling in 2012.
Not 2013, as you earlier indicated.
I don't think so. I mean, do you have those records of?
We probably do have a record, but it's not with me. It's with some other department.
Yeah. The town hall meeting was in 2013. 2014 in January. That was a result of sampling that had been done by Michael Pua, the investigator at Carlton Forge, much earlier. So I'm almost positive it was 2012 when I started calling, and I continued calling into the 2013 year. Then I continued calling in 2014 after the town hall meeting, but not as frequently because it improved a little bit. So, and now my colleagues, I transferred from there to get away. My colleagues are continuing to call regularly. There's been one notice of violation given by AQMD to Carlton Forge Works just about last in December regarding the metallic odor coming from Carlton Forge Works, but the teachers are continuing to call. So this is an ongoing problem. But yeah, I just, because I was under oath, I started thinking, no, it was 2012 when I started. So
Thank you for the correction.
thank you. Bye.
Senator has a question.
Ma'am, you started calling in 2012? What kind of response did you get from AQMD? Did they come out to see you?
Yes. Michael Poole was the inspector. He began a report. He would take a report when I would call, and just 9, 10, 11, 12. Yeah, it was 12. He would take a report. He started, and I told him there's something very serious going on here. You've got to help us. And he went to Carlton Forge, and he took several samples from just outside their bag house, found that they were emitting hexavalent chromium, cadmium, nickel. It's all public record in the town hall meeting on the AQMD website from 2014. It was the community was informed in 2014. I was able to see the records in end of 2013. I was working with Robina Sewell of California Safe Schools and other non-government agencies. So we were calling and saying, when are you going to have a town hall? When are you going to give us the results? When are you going to show us the results? And it was a long time, but they were meticulously going over the sampling that they had done earlier in the year. And then in December of 2013, Joe Liu, one of the board members for AQMD, put it on the agenda for the board, Rule 1430, which will control emissions from the grinding aspects of forging companies. So this is due to pass, hopefully, if the board of the AQMD does not veto it, in this March 2017, and it's going to require all 22 forging companies in Southern California, San Bernardino, and Riverside to, if they grind toxic metals, they're going to have to put some kind of pollution controls on. But we are asking for best available emission controls if they are near schools. So far, the wording says if it's 1,000 feet from a school. Well, we're asking the coalition and the teachers, some of the teachers, not all, but we're asking for 2,000 feet because in Paramount we have 3 forging companies, Matco, Press Forge, and Weber Metal, all forging within 1,600 feet of one public school that includes a preschool. So we're really hoping that AQMD will revise the distance to 2,000 feet, but I know that doesn't really apply to Aniplex, but in the sense of safeguards between schools and there are just so many sick people in Paramount. I find out more and more, and you were asking someone around the school. I do know personally 3 people in one home that grew up in one home. I know people who have moved from Paramount to get away, who were sick with cancer. I've heard, I met also people with, and I'm not saying Aniplex is the culprit or Aerocraft or Carlton Forge because we don't have that direct link of proof, but I'm saying there is a definite high amount of cancer.
You answer my question.
All right.
Thank you very much.
One follow-on question.
Yes.
You said that in 2012, and thank you for your honesty to come back to clear the record, but in 2012, you called AQMD, filed a complaint, and an inspector came out and took some sampling?
Well, he came out and took my report,
And then he took some...
and then I kept calling him, and I'll be honest with you.
You just testified that he took some...
Yes, but after I had called him several times, he went and
I'm trying to determine when did he take this sampling test?
I believe he took it in 2012. Isn't that correct? Took the sampling in 2012?
I have no idea.
I believe he took the sampling in 2012.
Is
and-
this, wait a minute, is
Well,
this about Carlton Forge?
If,
Yeah.
Yes.
Well, I think we need to move on.
I wonder if.
This is an issue about
I
Anaplex.
understand, but I'm trying to learn if it's all possible that the hexavalent chromium was discovered in 2012.
It was either late 2012 or more likely, now that I'm remembering, early 2013. When I believe it's starting.
Okay, you answered my question.
Hexavalent chromium was found at Carlton Forge, not at these kind of levels, but enough that it called for a town hall meeting.
But the district, I'm saying the district knew then, in 2012 or late 2012, that it was a problem.
2013, for sure.
All right, thank you.
Okay, we're going to have some witnesses for the district that can shed light on that. Thank you very much.
Okay, thank you.
Ms. Prusai?
I was just hoping before we broke, I wanted to ask Mr. McMillan if he might be prepared to testify upon return at some point about the specific measures, and in particular, the case with regard to Anaplex seemed more complicated in terms of the petition. There were more alleged sources of chromium-6, and aircraft, it seemed to be confined mostly to fugitive dust. And I wanted to understand each of those allegations and whether they are addressed by the list of measures in condition or in section 10 of the Exhibit 15, the proposed order, and if not, why not?
So I think if you're asking about paragraph 10 and the findings, all these measures listed here, I think we'll probably have somebody from engineering and permitting to speak to that issue.
Dr. Lerner?
Yeah, one question before we all die of starvation here. You alluded to the fact that about 500 feet from the company, there was a residential area. Was there a reason why you, just as a matter of policy or decision, you did not choose to put a monitor there so you could actually see what was going on at a place where it's residential, people are actually living there?
I can speak generally to the sampling plan. I think the details, there's probably other witnesses who can speak better, but just in general, the sampling plan was designed to try to find the source of hexavalent chromium. And so there was a plan to just start expanding upwind of Carlton Forge. And we, for lack of a better phrase, chased down where we thought the hexavalent chromium was coming from. Once we had done that, some monitors had previously been set, and we wanted to continue to get long-term monitoring. But as far as more details on the strategy, there's probably better witnesses.
Okay. We're going to continue with the testimony of Mr. McMillan after the lunch break. And if there are any other members of the public who wish to testify, we'll allow that toward the end of the day. I'm very reluctant to have members of the public testify and break up the continuity of the testimony that we are hearing. It's important that we understand it as thoroughly and completely as possible. So we'll proceed with the testimony after the lunch recess. And then if there are any other members of the public who wish to testify, they'll be given an opportunity at the end of the day.
Mr. Cameron, we do have one issue with one of our inspectors. His wife is actually expecting any moment and is anticipating a cesarean, I believe, operation on Tuesday. And so if you're thinking of further testimony, we want to make sure that he's able to testify since he actually is available. I don't know if this board plans to continue the hearing tomorrow, which is a Friday, but if not, we probably need to have him testify so that he could perform his fatherly duties.
Okay. How much, Well, we've spent quite a bit of time on that first paragraph. I don't know how much more time. When we come back, let's have Mr. McMillan continue for perhaps an hour, and then we'll go to the inspector. Okay. Thank you very much. We'll be in.
Excuse me, Mr. Chairman, I'm sorry. Do you anticipate that Anaplex will have to call any of the witnesses that it has this afternoon or tomorrow?
Number one, I don't believe that we will have time today to complete the district's presentation. And so I expect that it won't be till another day that we get to Anaplex. The hearing board is dark on Fridays. I don't know if the board members have other commitments on tomorrow, or if they wish to pursue it tomorrow. But normally, our next hearing day would be Tuesday of next week. We'll be in recess until 12:45.
Thank you.
Are we sure that they're not going to finish? It would be a shame if they finished and Anaplex wasn't here.
We're back on the record. Board members, did you have any further questions on paragraph, on condition number 1, page 6 of Exhibit 15? If not, we'll proceed on to Mr. McMillan describing the second condition, which appears on page 7, starting at line 6. Mr. McMillan?
Sure. So we touched on this a little bit previously. So what this condition describes is at Anaplex's discretion, they can conduct monitoring on their own site. We just will require them to prepare a sampling and analysis plan, and the goal of this is to make sure that they're following all district procedures and methods as far as how to collect a sample and how to analyze it. So there's a process in here for them preparing the plan and for the district to approve the plan. The condition then goes on to state that this information can be submitted to us when we take a look at our own monitoring data for comparison against the 1 nanogram per cubic meter threshold. And they can present this information to us, and we will, treat that information appropriately. It doesn't mean we carte blanche accept it. It means that we will scrutinize it and see how it may or may not apply to that 1.0 threshold.
Mr. Vandenberg, questions for Mr. McMillan on that paragraph?
No, Mr. Chairman, thank you.
Thank you. Mr. McMillan, can you tell us about the quality assurance effort with respect to the Anaplex monitoring?
As far as the details on that, I'm going to have to defer to another witness who would be able to answer that.
Okay. Board members, Doctor?
I'm a little confused. I think it's fine that they sample for their own information and that you sample, but the final determination has to be on your what you found. Otherwise, it's like having, the wolf in the hen house. It's just not a good idea. There's too much at stake here. For the community, for the reputation of their company, for our reputation. Everybody's involved in this. And I think it's perfectly fine, and I would encourage them to do it, because they have an idea of where they are, and they can compare their own data to yours. But yours is the gold standard. I would really, I'm a little bit concerned about that statement at the very end. The last sentence here, beginning the first 2 words on line 14. I think they're not in the business of making that determination. That's just not that's not an appropriate thing as far as I'm concerned. And I would strongly suggest that we talk a little bit more about that and discuss it, because I am not in favor of that at all. I think they can submit that information for their own use, as using your technique or your equipment as the gold standard, because that's the only one we're going to make the determination by. But I don't think that we should take into consideration their things at all. I think we just ought to leave it alone. We can listen to what they have to say, but other people may disagree. I feel very strongly we have to follow this, the logic of this. The district is responsible for making sure that the company is adherent to the norms that we are recommending. And that's the end of it. I don't think there's anything more to say.
Is there a question? Did you have a question, Doctor? Did you have a question? Did you?
Why are you doing this? Why is that last sentence in there? Sorry, thank you.
I think the operative word is shall consider.
Over to dictum, I'm sorry.
Sure. And I think we share the same exact concerns that you're expressing, that we want to make sure that the district is making its own judgment and the district is using its own data when making these determinations. That said, if the facility can provide information to us that is useful, that we feel it may be appropriate. Now, let me present an extreme example. Say, for example, we have monitoring data that we've been collecting at our current monitors there, and through a sampling and analysis plan that's been approved, there's monitors that are placed on site at Anaplex. And we've found that those monitors are really very good source monitors, and we find that they're telling us a lot what's happening about the source of emissions. Say, for example, those monitors that we believe, and they're following district methods and procedures, are showing that the emissions are actually very low from the facility on a particular day, and that the source, and there might be good reason to believe that. There might be other evidence that would corroborate that. We might know that the facility was shut down that day. There might be other pieces of information to take into account what's happening at the facility. But meanwhile, the monitor outside still shows a high level, and we might know that maybe there's another source nearby that suddenly something happened at another source. So taking the weight of evidence all together, I think, is the approach that is that we're going for here. It doesn't mean that we automatically will use their data to usurp our data or to substitute for our data. It is meant to supplement and provide additional information for us to consider to make sure that any curtailment that occurs is actually addressing the problem.
Mr. Wong, does that sentence require the district to accept Anaplex's data as valid?
No, it does not require the district to accept the data. I mean, we shall consider it, but we can always reject it.
Thank you. Ms. Bird?
Would it be more palatable to say the district may consider? Put shall in there as a word saying that it definitely will do that, when it doesn't sound as if that's really what you're saying. It sounds more like the district is saying, and I can be wrong, Mr. McMillan, sounds more like you're saying that you may consider it.
Well, I think may consider, I think we always consider it, because if they're going to provide data to us, we'll consider it, and then if we don't think it's appropriate, we'll just reject it. But I don't think it's the decision where they submit data and say, oh, we don't have to consider it, so we're just going to ignore it. I think the district typically looks at the data and decides whether it's, relevant, and if so, they'll consider it. If they think it's not relevant, they'll just say, hey, we're not going to accept it.
Well, I think the way the sentence reads, and maybe it's just my reading of it, it says that the district shall consider it in concluding whether the action level has been exceeded. And that, to me, is a little different than saying the district may consider it as evidence in concluding.
I don't know if you're trying to get at maybe shall
Maybe
consider
semantics.
as appropriate, shall consider as appropriate, or I don't know if.
Mr. Vanderberg,
Something to think about.
I understand.
how do you view that sentence? Do you view it as meaning that the district must?
It's one of the few sentences that I totally agree with, but the optic considerations aside, I understand Board Member Byrd's concern about it looking like that the district is being forced to conclude, but this is, I think, Mr. Chairman, based on your line of questioning, it's a little more accurate to say that this was put in there by Aerocraft. It was put in. And we are in negotiations right now with the district on having a MET station, located on Anaplex, because the closest MET meteorological stations are Compton and Long Beach, 5 miles away. I think it was put in there to make sure that the district analyzes it, and then they are not forced to conclude one way or the other. So we feel pretty strongly that this should be shall, but we don't think we're not taking away the discretion. I mean, we're not taking away the discretion at all of the district in doing this. I think it was put in there. I wasn't involved in drafting Aerocraft, but I believe it might have been put in there because Aerocraft was about 2 or 3 weeks ahead in terms of locating a MET station on site, and there was some question as to off-site sources. There's a company called Paramount Grinding immediately to the west of Anaplex. We have no data to show whether that's contributing to Anaplex, and it may not be. but I think the idea is just for equity purposes.
Well, I think, we could clarify, of course, if Anaplex agrees, so we can say something like, and I'm certainly open to language, the district shall consider Anaplex's evidence, but is not required to use the evidence in concluding whether the 1.0 nanogram per cubic meter. I think that's what it means, but if you want more words to clarify that, we could put that in.
Board Member Burden, Chairman Camarena, we would be fine with, that or notwithstanding or whatever, just to capture
What are you
that.
saying? I don't hear you too well.
I'm sorry, Senator Holden. We would be fine to capture that idea the way that, Council Wong has represented it, which is that, a notwithstanding or something that shows that the district maintains its discretion, even though it shall consider it.
Okay, after the break, perhaps the parties can present the board with some acceptable language. Any other questions on
Yes.
condition number 2, Senator?
Right. Mr. Wong, Ms. Byrd, Dr. Leonard, and now I am concerned about that paragraph. Now, I just learned that you did not incorporate this paragraph into the stipulated agreement. It was done by the respondents.
You back up, what paragraph are you talking about?
Yeah, this paragraph which deals with shall, 7.
Paragraph 2.
Right, you're concerned that we didn't first put it in there?
Did you put it in or did the respondents put it in?
No, this was, again, you weren't part of the proceedings, but this was a condition added to the aircraft stipulated order for abatement. And so, again, Anaplex had been insisting on a stipulated order for abatement that would basically be the same as the aircraft, so we just ported that over.
It's been pointed out already that I was not here when they made the final decision on aircraft.
Right.
I probably would have raised some questions at that particular time as well. And in retrospect, I will. But let me just say to you that this paragraph gives the authority, shall give the authority to the respondents to become self-policers, policing themselves.
Well, I disagree with that.
Well, I know you disagree, but that's going to be the end results.
I don't think that's the end result.
Otherwise, you have what's called a dispute. You find one measurement, they find another, and now you're in a dispute. Now you need a dispute resolution.
No, if there's a dispute, the district decides.
Ms. Brusek?
I think we've heard from both parties, that both parties are in agreement that the final decision as to whether or not to consider that evidence remains with the district, and both parties are willing to put in language to be decided to make that extremely clear.
Well, I may not agree with the district because then it becomes a loophole. We'll wait for the final language of it, but I'm telling you right now, it'll be argumentative later on. I mean, I'm telling the truth. You understand what I mean? At least you're fair about it.
Okay, we're going to see the language after the break, and we'll be able to discuss it at that time. Any other questions on condition number 2? Mr. McMillan, number 3?
Sure. So this third condition explains what happens if the 3-sample average goes above 1.0 nanograms per cubic meter. And it requires an email to Anaplex, followed up 2 hours later by a phone call with Anaplex to discuss the curtailment and to say, here is the data that we have, and here is our determination on this data. It provides an opportunity to discuss with the facility what the logic and reasoning is behind the district's decision. Anaplex at that time could present other information that we don't have that they think might be important. And so this lays out that process. I do want to note that in here there's the timelines that are set out are as a 3:30 p.m. email followed by a 5:30 p.m. phone call. I believe there's been some conversation about the timing of those, because that is the exact same timing that we have for the aircraft order. And given that it would be difficult to have two conversations at exactly the same time, there might be some reason to change that.
Yes, and I believe Bill Funderburk and I are in agreement that the time needs to be changed. My understanding is that we have changed the time to 12 noon, is that correct? And then we would have this conversation at 2 p.m. Okay.
Yes, that's to comport with Anaplex's operating hours of 6 to 2:30 p.m.
Ms. Byrd?
I know when we heard Aerocraft, that the reason that they were allowed to continue until midnight of that day had to do with heat treating processes for customer specifications. For this particular case, there's no explanation as to why it continued to midnight, and I was just wondering what that might be.
I think the only explanation is that we wanted to mimic the aircraft order. And if Anaplex is agreeable to an earlier time, we certainly would not oppose that.
Yeah, well, like I said, I was under the impression that it was because with Aerocraft, they would be in the middle of a process. And if Anaplex is not in the middle of a process, then why can't they shut down when you notify them to shut down?
Oh, that's a good question that should be asked to Anaplex.
Okay.
But we'll be happy to address that either as part of the district's case or as part of our case.
But I guess the question is whether you can agree to an earlier time. If not, then I guess they won't agree, I guess.
We'll make that an assignment for your break. We're off the record. Back on the record. Any further questions on condition number 3? Number 4, Mr. McMillan.
Sure. What this condition lays out is what happens when it specifies when Anaplex is able to resume operations after a curtailment. And this occurs only after they have received notice from the district that their 3 sample average is below 1 nanogram per cubic meter. And again, this is a rolling 3 sample average.
Questions? Ms. Prusak? She's thinking.
I'm trying to do math, which is hard for her.
You want to go off the record for a moment? No? Okay, let's proceed on to number 5.
Number 5.
Senator?
This equipment you're talking about may resume operation of any processes and equipment shut down as a result of the Chromium action. What equipment I guess you have a list of it in the back, but can you be specific about what equipment that causes the excessive emission?
Well, probably Anaplex can speak to that, but we believe that any equipment or process that can potentially emit hex chrome needs to be shut down.
Well, I'm looking at the equipment in this exhibit, in this book, number 10, page 16 and 17.
Oh, exhibit 10, I'm sorry.
10. Yes, it's 10.
Well, it's like 10.
I'm sorry
Talking about exhibit 10?
No, it's just page. What exhibit is this?
Well,
16. I'm sorry. 15.
You have
What exhibit?
You have
is it?
tabs on there. There are tabs on there.
The individual, then it's 10.
Yeah. Okay, I think you're looking at it.
10 on page
I believe it.
16 and 17.
16 and 17.
And you're looking at Exhibit 10 or 11 now?
It's exhibit 10.
That's aircraft.
Oh, oh shit.
Right, aircraft.
I didn't hear that.
Never mind, go ahead, I'm sorry about that. But let me ask you a question. Do you have any quenching process at this?
Well, you shouldn't be asking me
Right.
about whether they have any quenching process, because I simply don't know.
Not okay, thank you, sir.
Okay.
Where do I get this?
Okay, now we're on to 5.
So number 5 provides that Anaplex will provide access to district staff to conduct any sampling or monitoring or testing during their normal operating hours.
Questions?
Sampling monitoring.
Number 6 is self-explanatory. I guess that takes care of it. Board members have any general questions? Ms. Prusek?
I have a question on number 6. I wanted to understand why the words shall continue to implement the measures set forth. In aircraft, the word was shall expeditiously, I believe, implement. And a review of the measures shows I don't believe they are all currently implemented.
I guess Anaplex should probably best, I thought they said that they were all implementing all these measures, but perhaps not.
I mean, we'll have to go over the measures one by one, but as I'm reading them, they don't all seem to be. Some of them don't seem to be possibly already implemented. One in particular says in 30 days, so.
Yeah, and I agree, then we should probably amend that language to indicate that they shall continue or to implement or expeditiously implement the measures.
Should we ask if that's something that Anaplex is agreeable to, changing that language?
And I don't think that there's a problem at all. This list was developed from a couple of communications with the district, and because of the timing, some of this list was in, for instance, submitted December the 13th. I'm sorry, let me speak louder. Some of the pieces and tasks on this list were submitted December 13th, so that's why they might be the wrong tense in terms of future looking. But my understanding is that we don't have a problem with the language.
Okay, thank you. I also wanted to refer to, going to have to refer to Aircraft's agreement, which I know is in a different case, but I wanted to understand why 2 provisions are, I don't believe I see them in here, one of which was condition 6 on page 10 of that order, although I don't know if the pagination has changed, but within 30 days of the order, Aircraft shall submit a written report documenting completion of implementation of certain measures. Is that something that the district would like to see, or?
Yes, that, I think that was one that may have been inadvertently omitted. Is that the one, that's number 6, you say?
That's correct.
Okay, yeah, and I think the reason why, and this is actually a subject of a little bit of dispute, the aircraft actually, aircraft had actually included in one of their conditions HEPA cleaning, which, because we were trying to kind of make it site-specific Anaplex, I think that got eliminated, and so all these references to HEPA cleaning got removed. But I was talking to engineering, and they feel that perhaps what can be done is have Anaplex submit a housekeeping plan just to ensure that housekeeping measures are taken and that it would be approved by the district. So that was our thought about handling that. And we can still have this reporting after the housekeeping plan is approved.
Okay, so, and also, I guess the question was more generally, do you want any written report with regard to how they're doing in terms of the measures that are listed in condition or in number 10 of the,
Yeah, I don't know if that was required in the aircraft order that they report back on the measures, but, oh, yeah. Well, this is, I think it's paragraph 8 of the, going back to the dreaded aircraft stipulated order. And that also was not included here. That's one of the changes that were made that was not apparently, perhaps inadvertently left out, but we did want documentation of the implementation of the measures taken, and that was removed from this one. I think it makes sense to maintain the documentation.
okay, so we had added that in, right?
Right.
Respondent shall maintain documentation. So can we add that in? Maybe that would take care of everything.
I have no problems with it.
So then the question is at the end of 6, then condition 6, now we're back in Anaplex, to add at the end a second sentence which would say respondent shall maintain documentation of the implementation of, here it's A through U, but here it would be whatever they are.
A through Z.
A through Z, and make available upon request to the district. So essentially just taking that sentence from condition 8 for the aircraft agreement and adding it here.
Mr. Vanderburg?
Mr. Chairman, we're trying to be cooperative, but we don't even have the aircraft settlement.
Okay, then
here
I'll read
with
it
us.
again.
And I just want to make sure that there's and you can overrule it, but just a standing objection to bringing in this other stuff from the other case. It's really, we're trying to be cooperative, okay? But it's very difficult in terms of we knew the aircraft settlement 3 weeks ago when we looked at it.
Okay, Ms. Prusek is going to read it again slowly.
That's right. And it's not in terms of evidence. I just want to make sure that this agreement is strong and that anything regarding any kind of documentation or follow-up that is needed for the district is also put into this agreement. And so the sentence, I'll read it more slowly, is respondent shall maintain documentation of the implementation of measures A through Z and make, I'll put in a word, it available upon request to the district. Just a record keeping.
Excuse me, Mr. Chair, can I talk?
We're off the record.
Where are you getting this from?
Mr. Chair, I think that we're fine with it, but.
We're back on the record.
Mr. Chair, I'm sorry. I think that we're fine with it. If we could just confirm it on the break and add it to our increasing
Workload.
Yeah, yes, that Dr. Lester and I can review.
Okay.
Actually, one just minor clarification. This is probably something we should correct in the aircraft, but it's upon request by the district, not to the district.
Thank you for that.
Okay.
And then
Any
one
other
more.
general questions, Ms. Prusine?
I had one more with regard to the retention of jurisdiction. I'm concerned about this because the testimony of Mr. McMillan was that the 100 in a million level that we're looking for as a placeholder while the 1402 process goes underway, which could be as long as, I assuming about 2.5 years, okay, total. Possibly not, but, so I don't have a problem with the December 31st, 2018. What I do have a problem with, which I feel is a little unclear, is or until respondent has met all conditions and increments of progress hereunder, whichever occurs first. My concern here is that the most relevant condition is the ongoing condition, number 1, which has to do with the 1.0 nanograms. And my concern is, what if every one of the measures A through Z is put into effect, but we are not at the 1.0 nanograms? Does that mean that this self-destructs? Or I would much rather have just a jurisdictional date, or we could say, or we could say December 31st, 2018, or until a 1402 plan, a Rule 1402 plan 1402 plan is fully implemented, one or the other, or something along those lines. But as it's written now, that's concerning, that it could end a month from now.
From what I understand of this condition is it has to meet all the conditions, and it's true they could meet those measures, but in addition, they need to continue meeting the 1 nanogram per cubic meter. And if they don't meet that on a, I assume, a regular basis, then the order would not end. At least that's how I would interpret it.
But that doesn't make any sense, because then the question is, for how long? Because the only outside date that's in here is December 31st, 2018. So
There has to be some point in which the district, I think, feels satisfied that they've kind of accomplished 1.0 nanogram on a fairly, on a consistent basis. And I'm not sure how they will make that determination, but I assume they will make that determination. The other language you propose about 1402 is acceptable to the district.
Okay, I guess I'll add that to the Anaplex pile, unless they can come up with a better suggestion.
Mr. Vandenberg?
Yes, Mr. Chairman. Again, we're here to cooperate. It took us a little longer, a few weeks, than aircraft did, with the many fewer resources to get to where we are. We know what the problems are. We know what the tanks are. We're going to be talking about that when we get to put on our case. Aircraft is under a 1402 also, and if it's that big of a concern, if you're concerned about transparency and everything with the public, then shouldn't aircraft's agreement be amended too? It just seems that we're adding on to things that, frankly, as Senator Holden actually pointed out in the aircraft source test report, which I think he was correct to bring up, Exhibit 10 to the district's exhibits. On page 13, the last paragraph on page 13 of the aircraft source test, there's a comparison between aircraft and Anaplex by the district, where they basically say that aircraft's operations are much bigger, much more expansive, and more dispersed. Anaplexes are smaller and concentrated, and they're likely to be equivalent in terms of emissiveness. And so that analysis was done by a district. My only point is the idea of aligning the two agreements was because the district had made the conclusion on December the 13th in its source test that Anaplex and aerocraft emissions were somewhat I mean, the word wasn't equivalent, but the paragraph speaks for itself. So.
Okay, good point about perhaps at some point amending something I did not catch in the last agreement. However, I've caught it in this agreement, and I don't think we can have it both ways. Either we're aligning the documents, and there's no objection to that, or we're not. And so I need to make sure that we look at each one separately. And while we understand the concerns of both parties, that they all be on level playing fields, we need to individually analyze each order that comes before us.
If you can understand my point, is just kind of I'm concerned about, and that change is fine because we're already in the 1402 process, we're in the 1402 pipeline, but I just want to make sure that I just want to make sure that what Anaplex agreed to this morning when in the opening statement is the deal, somewhat close to the deal that it gets because it believes that that's what the deal that was offered. Thank you.
Thank you. Senator?
Well, I think the point you make is a level playing field, that each should be treated equally. I think that's what you're saying. Regarding aircraft and Anaplex.
Did you want me to respond, Senator?
I think that's what I think.
Anaplex recognizes that the operations are vastly different. The district does too, and the report that you brought up, the aircraft source test report, what I was saying is not equal, but similar or equivalent. And so when we hear from board members who approved the aircraft settlement and who are saying that they want to change things that are in the Anaplex settlement that are identical language, the only concern that I was expressing, even though we're willing to accommodate the board, because we want to get this signed as soon as possible too. Okay, thank you.
I think it's my understanding, Mr. Chairman and members, that there'll be a periodic review of aircraft anyway, of their stipulated agreement down the road. There will be.
Comeback date?
Yeah.
I was looking to see if there was.
There will be a review.
There is not a comeback date. That doesn't mean that we cannot, at some later date, require one, or that the district cannot seek one. There is one? And what is that? I don't see it in the order.
I think we had agreed in the aircraft for a comeback date. I think the idea was it in March or something? I don't recall the exact date.
Was it written or was it verbal?
It was verbal.
Oh, well. Sorry about that. If it's not written, it's not required.
We're off the record.
It's a possible comeback date. Depending on we have additional slippage by some part.
What are we going to do about it?
We're back on the record. Any further questions regarding the proposed order in general?
I have questions on the proposed order, but not on the ones that Mr. McMillan has testified to. I have on the specific measures, but I understand there's a different witness.
Let's, Ms. Prusak has some questions on the specific measures, and you have a witness.
Yes, I think we'll have.
It's gonna take Mac too. I don't know how long this will take. You expect your questions to be long?
I'm afraid we'll have to call another witness to testify about the mitigation measures, so we probably need a slight break before he can come down.
Okay, in the meantime, let's take the inspector that,
Okay. Okay.
okay, we are on the record. Mr. Wong?
Yes, we have Ariel Satani here. Will you please state your name, spell it for the record, and indicate whether you've been sworn in?
Sure. Ario Soltani, Areio, last name S as in Sam, O-L, T as in Tom, A-N-I. I'm an air quality inspector with the Toxics and Waste Management Unit, and I have been sworn.
Okay. Let me gather some exhibits. Oh, right, that's the PowerPoint thing. Okay, great. Oh, why don't we just go through these evaluation that you established, okay? All right, okay. And then, inspector's reports, here's a copy of it. Thank you. Okay. Mr. Salantani, could you please indicate to the board how long you've been in, well, first of all, are you an inspector for the Anaplex Corporation?
Yes, I'm the toxic inspector for Anaplex.
And how long have you served in that role?
I first inspected Anaplex in October of 2015.
15 or 16?
15.
We'd like to introduce the next exhibit. I think it's what now, exhibit
17.
17, okay.
Excuse me, Mr. Chair. We don't really have an exhibit. We have the exhibits that were provided through Exhibit 10. I didn't know if there was are we marking these in order, or I don't?
For the district, yes, this will be Exhibit 17 for the district. And you were asking about Exhibit 10?
No, I have a binder that we were provided with the exhibits as a courtesy by the district, and we have the exhibits that we are prepared to offer ourselves, but this only goes through 10, and I want to know if 11 through 16 had already been introduced, or I missed it, or if they or if they are hearing board exhibit number or what?
Well, I think one of the problems is some of the exhibits from, starting from the beginning, were based on when it was a joined case. So we'd have exhibits for aircraft and Anaplex. So
That answer your question?
So is this I'm just curious, is this the first exhibit that you're offering?
No. Up until today, this morning, we had exhibits 1 through 14, and they were all introduced in the aircraft matter.
Okay, I'm sorry. I got it. I was just lost.
Actually, 1 through 10 were first introduced in the joint matter before it was bifurcated. Then 11 through 14 were introduced in the aircraft, and 15 and 16 were introduced this morning, that being the order and the list of equipment, and now we're at 17.
Thank you very much.
The package distributed by Mr. Wong, it's a multi-page package. On the first sheet is a notice of violation P64514. The package will be marked as exhibit number 17. 17. Mr. Wong.
okay, thank you, Mr. Chair. Mr. Saltani, could you please identify Exhibit 17?
Exhibit 17 appears to be notice of violation P64514 that I issued on April 8th, 2016, and the accompanying report.
And would you please explain the circumstances upon which you had issued this notice of violation?
Yes. I was at Anaplex to conduct the Quarter 1 2016 inspection, as well as the annual inspection of the facility. And at a previous inspection, they had been issued a notice to comply to obtain a permit to operate for chromate spraying operations. I had detected the chromate paints on site, and they were explicitly forbidden from spraying chromate paints in any of their 4 paint spray booths. And when I was there on site for the inspection on March 7th, 2016, I found evidence of continued chromate spraying taking place at the facility. There was chromate paint present on site in their paint storage area, and also on their benches near their paint spray booths. I also collected samples of dried overspray from their filter media in 2 of their paint spray booths. The district, I submitted those samples for analysis, and they were determined to contain hexavalent chromium on the filter media. I also took samples of the paint in the paint cans, and those cans also show the presence of hexavalent chromium in the paints. So based on my inspection and laboratory analysis, I issued the notice of violation for applying chromate paint.
Now, attached to Exhibit 7.
Objection. Just 1 second. The testimony lacks foundation. It would be helpful to know just orientation, what the witness is talking about, just for the record. It's difficult. He's talking about there's no foundation that's been laid for this that I believe is proper. If you can overrule it, but I think that there needs to be more foundation to this, if possible, even if it's quick.
Ms. Broussard.
I'm trying to understand what you mean by more foundation, as to what?
Foundation laid to the testimony. He's got the NOV that he's testifying about. He's testifying to the truth of the matter, but there's separately a foundation that needs to be laid to that, leading up to what what specific, spray paint booth, what spray paint booth, where's the spray paint booth, what's the orientation?
Well, I don't think that's foundation. That might be more details, but it's not foundation.
I'm going to overrule it, and just to explain, I think it's fine for the inspector to be explaining his inspection and results of inspection, but if you would like more detail, either if he does not provide it during his direct testimony, you may ask those questions.
Thank you.
You may proceed, Mr. Wong.
Thank you, Mr. Chair. Again, attached to Exhibit 17 is some of the supporting documentation. Specifically, if you take a look at attachment number 1, it's the permit to operate F91612. And would you please point out to the board the condition that prohibits the use of chromate paints?
Sure. Permit condition number 14 to permit to operate F91612 reads, materials used in this equipment shall not contain any chromium.
And in the second attachment, which is also another permit to operate, does that also have a condition prohibiting the use of chromate paints?
Yes, it does. Condition number 14 to that permit to operate reads, materials used in this equipment shall not contain any chromium.
Now, you had earlier referenced a notice to comply that had been issued, which I believe is in attachment 3. Is this the notice to comply that you were referring to?
Yes, it is.
And that was issued when?
The notice to comply was issued on December 4th, 2015, but it stemmed from my inspection taking place on October 9th, 2015.
And during that issuance of notice to comply, and essentially that was to, because now why did you issue this notice to comply?
So I was, October 9th, 2015 was my first inspection of Aniplex. And I was there actually for a limited inspection, a quarterly inspection of their chromic acid anodizing tank. We inspect hexavalent chrome plating and anodizing operations quarterly. While I was there, I noticed that the paint spray booths had a greenish overspray on their filter media. Green overspray in the aerospace industry is usually indicative of a chromate-containing primer. I'd seen that at other type facilities. So although it wasn't part of my quarterly inspection, I asked for permission to inspect their paint spray storage area. And while there, I detected on the product labels of several cans of coatings that they indicated that they contained chromate spraying. They contained chromate in the coating. And so after bringing that evidence to my supervisor, we decided that the correct course of action would be to issue a notice to comply to obtain a permit for chromate spraying.
And during this inspection on October 9th, 2015, did you encounter any representatives from Aniplex?
Yes, I did. I've met with and spoke with 3 individuals. One was Richard Wyatt, who is the Vice President of Quality. And later I met with Carmen Campbell, President of Aniplex, and she granted me consent to inspect. And then lastly, I met with David Wong, Vice President of Production.
And did you have a confrontation with Mr. David Wong?
Yes, unfortunately I did. When I was in the paint storage room and I had detected that coatings contained chromate were present on site and that was in violation of their permit, I brought that to Ms. Campbell's attention, and immediately afterwards, Mr. Wong, who had not previously identified himself, had entered the room and confronted me directly to my face and used profanity at me.
The next attachment, attachment 4, please describe the next attachment.
Attachment number 4 was Anaplex's response to the notice to comply that I had issued for chromate spraying. In their response, they drafted a letter signed by Ms. Campbell where they stated that they had identified 3 products on site that contain chromate, and that they had researched those products and they were able to find substitutes that were chromate-free for 2 of them, and that the third product, they were not able to find a chromate free alternative, and so they had discontinued its use. And in addition to that, they'd also posted signage throughout the facility indicating that to not spray any coatings containing chromate. And they attached a copy of that sign to this letter.
And perhaps remind the board, after you received this letter, you subsequently revisited Anaplex and discovered the use of chromate paints. Is that correct?
That's correct. This letter is dated on December 30th, 2015, and I was on site on March 7th, 2016, and at that time detected additional chromate-containing coatings.
Now, the attachment, well, it's labeled attachment number 24, and you obtained that on your visit in March of 2016, is that correct?
I think that this spray log I did not receive on the day of my inspection, but I received subsequent to my inspection upon request.
And would you describe the spray log that was provided to you?
Yes. Anaplex maintains 2 sets of spray logs. One set of spray logs lists their coatings that they apply in spray booths 3 and 4, and the second set is logs their usage of coatings in booths 1 and booths 2. Booths 1 and booths 2 are the booths where they apply primarily epoxy primers, and this log lists epoxy primers that were applied in booth number 2.
And what type of epoxy primer is listed on the usage log that they indicated they had used?
On this log, they identify the epoxy primer being used as AXO 23371TY1.
Now, the next attachment, did you do further investigation as to whether this AXO primer contained chromates?
Yes, I did. I don't know if it's included as, not all of my attachments to my report are included here, but on the product label of this container is the number 23377, and 23377 refers to AXO product 10P20-13. If I remember correctly, I think 23377 is either the mil-spec code or the color code of it. So in their logs, they refer to it as 23377, but the manufacturer product code on the MSDS sheet is 10P20-13.
And where in this MSDS sheet indicates that it contains chromates?
On the first page of the MSDS, under section 3, chemical name, the first component of this coating is strontium chromate.
The next attachment in this exhibit, attachment number 22, would you please describe the next document, attachment 22?
Attachment 22 is a copy of a AQMD report by by the AQMD laboratory, and in this report, it has the results of analysis of the samples I collected at Anaplex on that day.
And where in the analysis does it indicate it has chromates in it?
So on the third, on the, I guess the second page of this report, on page 2 of 2 of the lab report, samples 2 was a sample of the coating AkzoNobel 10P20-13. And on the far right, it lists that it contains 560 parts per million of hexavalent chromium, or in other terms, 0.06% hexavalent chromium.
Now, in addition, you had taken a look at the AER reports filed by Anaplex.
That's correct.
And does that report indicate that they were aware that these coatings contain chromate?
Yes.
And let me submit that as in the following exhibit, which I guess now is Exhibit 18. Would you please identify in Exhibit 18 what Exhibit 18 is?
Excuse me, the document distributed just now by Mr. Wong. First page is titled Annual Emission Report. It'll be marked as Exhibit 18.
Exhibit 18 is an annual emission report submitted by Anaplex Corporation to the AQMD for the reporting year 2015.
And where in that report, could you please identify where it indicates that they were aware that the primers they were using contain chromates?
Yes, so in the reporting year 2015, which was received by the district, the first page is the signature page, which has the Ms. Carmen Campbell's signature on it, dated 6/21/16. This report, my understanding is, I work in the Compliance and Enforcement Division. This is handled by a separate group, but it's my understanding that facilities enter their emissions in electronically on a district website, and then after the information is completed, they print out a signature page, sign it, and submit it to the district along with applicable fees. So what this packet represents is the information that Anaplex Corporation submitted to the AQMD electronically. In this report, Anaplex Corporation identified 5 different coatings as containing hexavalent chromium. Specifically, the coatings, they use the description, they describe it as AXO BMS-10-11, DEFT 85582, DEFT FR 1786, AXO 23377, which matches their spray logs that I had seen earlier. And the 5th category was their emissions of chromium from their chromic acid anodizing tank.
Senator.
Where I see group 13 describing chromium, where are you getting these other information? That's in the Exhibit 18,
In Exhibit 18,
page 101.
yes, so the first page after the signature page is a summary of different toxic air contaminants and their associated fees. In the subsequent pages after that page, on, for instance, on page number 4, it's not numbered as number 4, but the fourth sheet of paper, it says Step 1 process, and it lists AER device ID, and there's an ID number. When you follow that column across, under material description, it describes it as AXO BMS-10-11, and then toward the bottom of that page, it lists, under toxic emissions pounds, it lists chromium hexavalent. So it's it breaks down the sources of hexavalent chromium emissions by coding and by unit type.
Thanks for the help.
No problem.
Yeah, thank you. And then would you please describe the later investigation you took place in terms of trying to trace the source of the high hexavalent chromium emissions found in Paramount?
Are you referring to the
No, I'm not.
ambient data, or?
As you've heard earlier, the district had set up some monitors and were trying to determine the source of these hexavalent chromium emissions. Were you part of the team that was helping to locate what the sources of those emissions may be?
Yes. On October 26, 2016, I and another inspector, Inspector Michael Haynes from our toxics group, arrived at Anaplex to investigate elevated hexavalent chromium levels in the Paramount area, specifically two facilities, Anaplex and Aerocraft heat treating. Anaplex was also due for its quarterly inspection, so we conducted their quarterly inspection as well as the investigating elevated chromium levels.
And why was Anaplex chosen as a potential source of, or at least I thought they were a potential source of hexavalent chromium emissions?
Anaplex maintains several permits to operate with the AQMD, including a chromic acid anodizing tank, which uses hexavalent chromium, which is a known potential source for hexavalent chromium. In addition, earlier in 2016, I had taken enforcement action against Anaplex for spraying of chromates in violation of their permit and district rules. That was they were identified as a potential source of hexavalent chromium in the Paramount area.
And did you later do a subsequent investigation of Anaplex to determine what the sources of hexavalent chromium were?
Yes, I've been to Anaplex several times since the initial quarterly inspection on October 26, 2016.
And what did you observe in terms of, let's say, their hexavalent chromium sources?
Specifically about hexavalent chromium, we had detected that recently Anaplex had, in compliance with district with an EPA ruling, Anaplex was no longer permitted to use a wetting agent known as that contains a compound known as PFOS. PFOS is an additive to chrome plating and chrome anodizing tanks in order to reduce the surface tension of the solution. It makes it splash less, in layman's terms, when parts are added to and from the tank. The those wetting agents normally contain a compound known as PFAS, which has been found to be detrimental to the health and the environment. So US EPA has banned their use, and there's been a substituted material, several of these materials that do not contain that compound known as PFAS. My understanding is on October 25th, 2016, Anaplex began using a non-PFAS wetting agent known as Hunter Chemical HCA in their chromic anodizing tank. We observed on the 26th, the very next day, that for whatever reason, that wetting agent was causing excessive foaming from their chrome anodizing tank. There was a yellow-orange foam and bubbles higher than the height of the tank, and a lot of foaming action on top. And we had noticed that we had brought that to the attention of Anaplex about that foaming. In addition, when using that wetting agent, the surface tension of the tank must be maintained below a level of 25 dynes per centimeter. That's the unit of measurement for surface tension. Per their records, the surface tension of their tank was at 37 dynes. So in addition to the foaming action, the surface tension was above the specification for that wetting agent.
And did you do readings of I understand the equipment is called the XRF, which reads chrome. Would you please explain that and what the readings were?
Yes. I'm trained by the district and by the representative from the manufacturer of this equipment. We have several units known as an XRF. An XRF is a handheld portable unit that is able to take measurements of surfaces, of solid surfaces, and determine its composition of certain elements. One of the elements in particular is chromium. The device unfortunately cannot distinguish between hexavalent chromium and other forms of chromium which are not human carcinogens, but it does give an indication for total chromium on surfaces, such as public sidewalks or other surfaces like that.
And you use this XRF machine on the sidewalk just outside of Anaplex, is that correct?
That's correct. On November 3rd, I with another inspector, Inspector Michael Pua, we...
November 3rd, 16?
November 3rd, 2016.
Senator, pardon me? We're off the record.
Sorry, Mr. Chair. Mr. Funderburg had to take a bathroom break. I wasn't sure if we were required to get permission from the board before we leave the room, but I'm here.
Okay, you're going to be representing the respondent while he's gone?
Yes, Mr. Chair.
Okay, we'll proceed. Thank you.
Yes, on November 3rd, 2016, I was participating on a sweep of Paramount businesses with several different, over 10 inspectors from the AQMD. We're in the Paramount area going door to door to inspect businesses. I was tasked with the XRF unit to investigate surfaces, public areas, and what we found was using the XRF, we detected significant levels of total chromium just outside of Anaplex's doors, along Garfield Avenue as well as Madison Street in public areas.
We'll be introducing this next exhibit, Exhibit 19.
Mr. Wong's distributed a one-page document. It's a table, no title on it. At the bottom, it does say Anaplex's chromic acid, Anaplex, and aircraft anodizing tank. This will be marked as exhibit number, I think it's 18?
I believe it's 19.
19, thank you. You may proceed.
Okay, thank you, Mr. Chair. Mr. Sultani, did you create this document, exhibit number 19?
Yes. I was asked to examine ambient air monitoring results in the Paramount area and to compare the results of the ambient air monitors to the operations at Anaplex and at Aerocraft.
And why did you choose monitors 14, 15, and 16?
I was looking at monitors 14 and 15 in particular because these monitors are located downwind of Anaplex along Garfield Avenue. The prevailing wind in the area is westerly, so wind is coming from the west to the east. These two monitors, 14 and 15, are located just to the east of Anaplex, downwind of the facility. Monitor 16 is located near the intersection, I believe, of Texaco and Madison Street, located to the west of Anaplex. So essentially it's a control to eliminate other potential sources of chromium and to eliminate that as a potential other potential sources to monitors 14 and 15.
Thank you. Under the column marked Anaplex's operations, you list the various types of operations. How did you obtain that information?
We had submitted an information request to Anaplex Corp. I'd issued a notice to comply to submit records of operations from Anaplex, and Anaplex had supplied to us spray logs that indicated when they were conducting spraying operations at the facility. They also supplied amp hour logs, which indicate when their chromic acid anodizing tank was being operated, when it was having current running through the tank, when they were using that. In addition, I also used my own surveillance of the facility. I've been tasked to conduct surveillance in the Paramount area on certain Saturdays and on certain Sundays to determine if certain businesses are operating on the weekends.
Thank you. And just to highlight a couple of the items here. For example, on November 5th, 2016, you indicate, at least under the Anaplex's operations, there was no spraying and anodizing, but maintenance, housekeeping. Is that correct?
That's right. Based on my in my numerous interviews with Anaplex personnel, my understanding is that the facility normally conducts spraying and anodizing operations Monday through Friday. If I remember correctly, I think it's typically between 6 and 2:30 p.m. I'll have to check my notes, but on Saturdays, Saturdays is when weekly maintenance and housekeeping takes place at the facility.
And looking again at the November 5th date, what was the monitor 15 reading on that date?
On
November 5th.
On November 5th, 2016, monitor 15 indicated that the ambient level was at 26 nanograms per cubic meter.
And again, there was no spraying and anodizing on that day.
The records I had did not indicate that any spraying or anodizing took place on that day. However, on Saturdays, per their interviews, maintenance and housekeeping takes place on that day.
Now, there's also, you had listed for November 24th, 2016, which I believe is Thanksgiving Day, none. None means what?
I was not, I did not personally surveil Anaplex on that day. Another one of our inspectors, she was conducting surveillance, and she did not observe any personnel on site, did not observe any operations taking place. Their spray logs and their anodizing logs did not indicate any operations taking place on that day.
And what was the readings on that day?
Monitor 14 on that day indicated 0.10 nanograms per cubic meter, and monitor 15 indicated 0.11 nanograms per cubic meter.
Thank you. Because Mr. Saltani has other pressing issues to take care of on Tuesday, there is a portion of the case that he was going to provide evidence on. Essentially, it's the roof, which was kind of left off the stipulated order for abatement. So we would like to do that while he's here. So we will present testimony about the roof.
Okay. Mr. Vandenberg?
Yes, Mr. Chair. We're going to object to testimony about the roof. It wasn't included in the petition for abatement. There's very little question as to whether there's even jurisdiction and whether the district should have amended the petition to include the testimony, to include anything about the roof issue. This is something that the district knew about since December 9th. They could have expedited the sample. The district has robust resources to collect samples and to analyze them. If they thought it was an issue, they took chunks of metal off the roof that has less chromium than a stainless steel fork, and then they analyzed it using a test method for water and not for solid waste. And so in addition to the fact that it really shouldn't be considered, what's the rule number, Annie?
Mr. Chair, Rule 4 of the hearing board rules allow the board to permit a petitioner to amend the petition based on new facts and new information. It also provides for the respondent an opportunity to amend their response, and that amendment of the response would have to be filed 5 days before the hearing, and there's criteria and the rules that provide for the reasons for the response, such as lack of jurisdiction, lack of proof, etc. In this case, Anaplex was informed of this information as recent as December 30th, I believe. The samples came to the district on December 29. We were provided on December 30th. If I do my number correctly, take out the holidays, it's maybe 1 or 2 business days. And as Council Mr. Funderburg mentioned, the district has not petitioned the chair to a request to amend the petition, and therefore the petition before the hearing board currently does not include any allegations regarding anything relating to the roof, and therefore Anaplex was not in a position to prepare any response to those allegations. Those allegations are raised for the first time, well, either December 30th when it was raised by the district, and for the first time before the hearing board today. We're looking at the documents for the first time. The hearing board is looking for the first time today. And I'll just highlight with another quick objection for the entire board that we have raised during a pre-hearing conference yesterday, a request that the district provide us with a list of exhibits and a list of witnesses. I remember in the pre-hearing December 8th, Mr. Chair, you specifically asked the district to provide the exhibits to the entire board at least 2 days before the hearing. As we sit here today, all these exhibits we're looking for the first time at the hearing today.
Mr. Wong, would you care to address the objection? Then I'll ask Ms. Prusek for a ruling.
Very good. I think they have indicated, and it's quite true, we received the results from the roof sample on December 29th, 2016, which is obviously well after the date we filed the petition. But nevertheless, the petition alleges a nuisance violation, and the roof is simply a contributor to the nuisance. So we don't think we need to amend the petition to specifically point out the roof as a source of hexachrome emissions. We believe that the petition adequately covers any source of hexachrome emissions from Anaplex, which includes the roof. We kind of went through this thing about the exhibit list and the witness list at the pre-hearing conference. Again, obviously, things have changed at the last minute with these stipulations, so we had had to revise it, and no witness list was required by the chair. Oh, yes, and, well, right, and Mr. Saltani has indicated, of course, that we were also denied access to the roof, so we couldn't even test it before earlier on.
Ms. Brusek.
I'm going to need a little time to rule on that because I'd like to review the petition and ensure myself that that this is adequately covered, because my initial thought was that in fact nuisance rule 402 and 41700 is adequately covered. However, I don't want to make that ruling without reviewing the petition, but I think it would make sense if we go ahead and question the witness with regard to the current matter before us, and then take a break and allow me before he continues his.
Actually, this is a good time to take a break.
Okay.
We'll take a recess, reconvene at 2:35.
Thank you, Mr. Chair.
We are back on the record. Before the break, we had an objection from respondent, and Ms. Prusak has reviewed the objection and the response from the district and the applicable hearing board rule. Ms. Prusak?
Yes, I have reviewed in particular the petition in this case, and based on that, I'm going to overrule the objection to hearing the testimony on the roof. I do not find a need to amend the petition. I believe, having again reviewed in particular the allegations with regard to violations of Health and Safety Code Section 41700 and SCAQMD Rule 402, that the district clearly alleged a violation of those rules due to high levels of chromium-6 emanating from Anaplex. And while in paragraph 15, the district was specific and specifically listed those results of the screening source tests, they did not purport to be exhaustively listing every potential source from the facility, and I don't believe they were required to do so in the petition, and I feel that the petition is broad enough. Moreover, I don't feel there's any prejudice on Anaplex's account, because Anaplex has been apprised of the results of the roof samples that were taken, and also, even though we're going to be hearing from a witness who will not be available next week, the respondent will have an opportunity to respond and prepare that response for next week. So based on all of that, and our rules stating that, well, I don't even have to go to that rule because I don't believe an amendment is required.
Thank you. We'll proceed. Just before we do, there was some question as to the comeback or status report on the aircraft matter, and the clerk informed me that indeed we did set March 16, 2017 as a comeback on that matter. Mr. Wong?
Thank you, Mr. Chair.
Is your mic on? Microphone on?
Oh, I guess not. Thank you, Mr. Chair. Okay, so we're going to now proceed on with the inspection on the roof.
Mr. Chairman, before he goes to the roof, I got a few questions left here.
Okay.
I mean, was there a fiddler on the roof?
It would be nice if we did have one.
Yeah.
Let me make it short. I want.
Well, Mr. Vandenberg has the opportunity at the moment.
Yeah, thank you, Mr. Chair, and I'll make it brief. You know where we stand. We think it's overbroad, but we accept the Vice Chair's ruling. The concern that we have is being able to bring back Mr. Sultani and not just cross-examine him now, but subject to whatever is later discovered, and also bring our own rebuttal witnesses to Mr. Sultani's testimony.
Mr. Sultani, I understand, is taking a 6-week paternity leave of absence, so he won't be available for quite a while.
Thank you.
Yeah. I assume there might be some other witness from the district who might be able to come back if there were additional questions? Or?
There may be. They may not know as directly as Mr. Sultani, but we do have other people who can probably address some of the questions.
Okay. With that in mind, board members, time is 10 minutes to 3, and we might need to go over beyond our normal adjournment time if we have too many or more questions than can be covered in the normal adjournment time. I don't know what your respective other commitments are for the rest of the day, but we'll get to that if we need to. Mr. Senator, you have...
Mr. Sultani, on Exhibit 19, you explained it in detail. However, would you explain to me on the column adjacent to 60 NA, 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 and then you give it a number? Will you explain what the significance of that?
Yes. Monitors, my understanding is I did not personally place the monitors on site, but the monitors 14, 15, and 16 began collecting data first on November 5th, 2016. Prior to that, those monitors were not in place. That's why the columns there read NA, because the monitors had not been placed there by AQMD personnel yet.
Exhibit 19 just talks about 2016.
That's right. They were placed, I'm sorry if I misspoke. My understanding is that monitors were placed there at those locations beginning on Saturday, November 5th, 2016.
All right. All right, now let me ask another question. You've been the inspector for aircraft and Anaplex, correct? Yes or no?
Yes, I inspected aircraft beginning this year, and I was the Anaplex inspector beginning in 2015.
Okay. Is aircraft downstream from its site location, source location?
Yes, aircraft is located approximately one block east of Anaplex.
Are they both downwind or upwind, which case may be?
My understanding is the prevailing wind is westerly. It comes from the west.
So it hits both of them.
And so, yeah, the prevailing wind comes from the west, and Anaplex is located to the west of aircraft.
Okay, there's a provision in the stipulated agreement, and I can't point to it right now, but it's on page 6, I believe. It talks about at the very end that it is determined that Aeroplex has resolved the problem, and if the source of the emission did not emanate from Aeroplex, they'd be allowed to resume using the equipment.
Senator Holden, our is here is not to testify about the stipulated order we had.
I understand. Maybe somebody can answer that, because that's going to generate a conflict between who, in fact, causes the emission. Did it come from aircraft or Anaplex? And you're going to have a dispute. Once you go to Anaplex and say, you're the source or you're not the source, the aircraft is going to say, well, we're not the source either.
Right.
Where did it come from?
Well, I think, again.
Because I haven't seen that, but I wasn't here when you finalized that one.
Right. There's a process built in which they can provide evidence that the district will review, and it's probably a little harder for Anaplex to argue that the aircraft is.
Mr. Wong, you're an attorney.
Excuse me, Mr. Wong I don't think he had finished his response.
Right, so it would be harder for them to argue that, but I guess, we'll look at the data and see, examine the windrows and see whether that's possible. It's probably not that possible, so we would reject that. It wouldn't be a dispute. It would be a dispute, of course, they're disputing it, but we would simply not accept that data.
Okay, well, I don't know what that means, because which way the wind blows is going to determine what happens. And what you're going to have then is one guy pointing fingers at the other.
Well,
being an attorney, you know what that means.
Yes, I do, but this is a situation where the district is in charge of resolving these disputes, and if there is one, they'll consider what the evidence is and make a proper decision, I believe.
I like that word where the district is in charge, except for the fact that we discussed an area that you're allowing Anaplex to police itself by coming up with information, submitting data, submitting it to the district for the approve or disapprove it.
Yes, and we certainly don't trust Anaplex completely, which is why we have all these conditions and require them to submit data to us to demonstrate any argument that they are not the contributor to the exceedance.
It's further my understanding then to comply with Ms. Bird's request or suggestion that you write something to clarify in that section, and have you done that yet?
Yes, I believe the parties have met and worked out something, but and we can get into that. But my understanding is we're trying to finish up with Mr. Sultani so he can actually enjoy his
All right, carry on.
paternity leave.
Ms. Purcell.
I had two questions for Mr. Sultani. First question is on Exhibit 19. I'm particularly interested in if you have any opinion on this. The first reading is on November 5th, and it's particularly high for Monitor 15, and the activity is maintenance and housekeeping. Is it your opinion that, given the fact that there were no results from prior to November 5th, that this high reading could be from previous days' activities, or is that not possible?
That might be a question for Monitor. My understanding is they take the sample that day, so it's that day's.
It's just that day, so they don't, it's not like.
It's not accumulated.
It doesn't accumulate?
Right.
Okay.
That's my understanding.
Okay, thank you. The other question is, are you familiar with the petition in this case?
I have a copy of it, yes.
And in particular, on page 4, starts on page 4, paragraph 15.
Hold on, he doesn't have a copy of the petition in front of him. That's the findings and decisions, and so we need to find the petition.
Excuse me, Mr. Chair.
Mr. Vandenberg.
Yes. Because Mr. Sultani's testimony seems to rely on the district's monitoring that it's conducted, we'd like to offer, at least as a courtesy to the board, exhibits we were planning on introducing in the respondent's case, but which we think are relevant to Mr. Sultani's testimony, that include all the monitoring results from the district's website through December 29th, because he seems to be commenting on things that, and there are no windroses attached to any of these as well. It would be really helpful if he's going to make a statement like, the wind blows westerly. Well, where's the windrows to show that? So I think we think that it would be useful to the board, and it would be not necessarily prejudicial to Aniplex, but it wouldn't be it would be fair, I think, just to have this, which is from the district's website, and has current monitoring results available to the board. Thank you.
Mr. Wong, Mr. Funderburg has a document that he believes would be helpful to this board in understanding Mr. Sultani's testimony. You have any objection to?
Well, if he's talking about the more results, I'm not sure if that really sheds any light on Mr. Sultani's testimony, because he simply was focusing on those particular days and the days of operation. So I don't think it's, we did plan to produce that as part of our case, but that was not going to be relevant to Mr. Sultani's testimony. In fact, he's not commenting about the wind direction at all, so he doesn't need windroses.
Sir, Mr. Chairman, he just commented about the wind direction. So not only that, but we would introduce this if we were going to ask Mr. Sultani about on cross-examination. So I mean, I'm just trying to streamline things, and I just think that having the information is not going to confuse things, but it will avoid conflating them. Thank you.
Board members, any objection to accepting that document?
I'm just trying to ascertain relevance. I understand that Mr. Sultani responded to questions with regard to wind direction, but they were one with regard to whether or not there is a concern, we should be concerned as a board as to any provisions that would allow finger pointing based upon who is to blame under the, of a particular reading under the order. And I'm not sure of, I had another item. thing in my mind as to relevance, but I'm not sure as to evaluating, and the other would be whether or not there is liability on the part of respondents for, or a violation of either Health and Safety Code 41700 or Rule 402, but that with a stipulated order at this point is not really relevant. So I'm wondering if you could explain further what the relevance would be at this point.
To begin with, it seems like there's some conclusions that are being drawn from, or the hearing board's trying to draw from the data that's being presented, and it's simply it's incomplete. You only have 3 of the monitors here. There's an attempt to have a discussion about upwind, downwind, where the stuff, where it's coming from, and why Anaplex. It seems that the line of questioning is that why Anaplex was targeted. Whether it was low-hanging fruit because it was a permitted facility versus unpermitted, or if it was a potentially high emitter based on the results that Anaplex had submitted. So to put things into perspective, having the data incomplete, I think that would help inform the hearing board's decision. We plan on providing this exhibit anyway on when we question Mr. Sultani, which we hope will be streamlined. Thank you.
Mr. Sultani is not in charge of air monitoring, and that is another witness. So if he plans to question Mr. Sultani about the air monitors, he's not in the position to answer those questions. So I'm not really quite sure what the purpose of introducing Winrow's data is.
Mr. Sultani is the lead inspector, it seems. He's been there he's not just the 1469 that has conducted one of the 40 quarterly inspections that AQMD's done at this facility for the past 10 years. He also has conducted numerous other inspections over the past 30 days. And I think one of the things he's been trying to get to the bottom of is where is the chrome coming from for monitor 15 and possibly monitor 14 and 13. And to the extent that that his investigation implicates what he has found in his site visits at Anaplex and in and around Anaplex, the data from the other monitoring stations is definitely relevant.
Are you seeking to dispute that the chromium is coming from Anaplex?
Absolutely not.
Okay.
Absolutely not.
It seems to me that for those days that are shown on Exhibit 19, it would be helpful to know what the readings were from some of the other monitors. And the reason is that by looking at the data, for example, 11.5, look across, and we know that where these 14 and 15 monitors are with respect to Anaplex, and then you look across at monitor 16, that leads you to a conclusion that you might not draw if you have data, if you are looking at the data from other monitors.
We have that, just with all, Exhibit 14, we have that information.
Okay.
And my only other point is, Mr. Funderburg had alluded to the fact that when he questions Mr. Sultani, the time to do that is now, I believe. I don't know if you declined to ask questions or we just skipped over Mr. Funderburg.
No, not at all, but we were just informed today that Mr. Sultani wouldn't be available for 6 weeks. He's on our witness list. I gave it to Mr. Wong this morning, and he's one of the 12 inspectors from the district that go to Senator Holden's concerns about what was going on during the inspections for the past 10 years. So we just found out about it, and yeah, we'll question him, and we'll question him just to clean up whatever the testimony is. But yes, we do plan on doing that.
Okay, the board appreciates your offer, Mr. Funderburg. However, as Ms. Prusak pointed out, the other data that I would want to, want to look at as I look at the data in Exhibit 19 is before us in Exhibit 14. So let's proceed.
If Mr. Funderburg has questions for the witness, he should probably ask them.
can't be thinking of three things at the same time.
I can come back to my
Yeah.
question if he has questions.
Okay.
Well, actually, we were in the middle of a question, so I might as well finish it. So we were talking about paragraph 15 in the petition. And my question, because I'm going to have another question for whatever witness it is who can talk to me about the proposed measures in the proposed order. I wanted to know if Mr. Soltani, if you could take a look at what's listed here and let us know if you agree that based on your inspection and any source tests, screening or otherwise, that were conducted, that you are aware of, if these areas that are listed are the major area, aside from the roof, of concern at Anaplex.
Based on the results of the screening tests performed by AQMD personnel, these elevated numbers are very concerning, and this has been a focus of our investigation and inspections of the facility, on ground level and at the roof above these equipment units.
But I'm sorry, maybe I wasn't clear, but I was looking at specifically at the petition, paragraph 15, starting on page 4. There are, I had counted 5 different sources that were identified during the screening source tests, including, for example, the chromate seal tanks, which are heated to near boiling, etc., failure to control air sparging. These allegations, are these the allegations of concern that you know about? And is this an exhaustive list aside from the roof?
These tanks are of great concern to AQMD, and in fact, we issued notices of violation for some of these matters. The dichromate seal tank did not have a permit to operate, and I had issued a notice of violation for that. And the air sparging of the chromic acid anodizing tank is without when it was being air sparged when parts were not in that tank. That is also a violation of district rules, and in the same notice of violation, that was also addressed. So these matters here are, we've taken enforcement action against the facility for that. Whether or not that's exhaustive, I wouldn't want to speculate on that. Our investigation is still ongoing.
Okay, so if I were to ask, I don't know, excuse me, who the witness will be, but the witness for the district who will later testify and go over the proposed order for abatement and the measures that are proposed A through Z, and I were to ask that person to identify which measures are addressing the issues that are listed in paragraph 15, and then that witness were to identify them, do you feel that if they address these issues, that would be sufficient?
I don't believe Mr. Soltani can really address that. But the screening source test was done with essentially pieces of equipment that the source tester believed to be very likely sources of hexachrome. But my understanding is that there's a lot of equipment at Anaplex, and there's no way they could have tested every single piece of equipment.
Okay, and whoever the witness is who will come and testify with regard to A through Z, that witness will have a better idea of what can be done at the facility that
I believe so.
Okay, so I'm just trying to get a handle on, I don't want Mr. Soltani to leave without me asking anything that's necessary. I don't have any other questions.
Ms. Byrd?
I asked this question earlier, and I don't know if you can answer it, but I thought I'd throw it out there again. Is there any reason that you know of from observing the operation where this facility could not shut down after it received a phone call and would be allowed to operate until midnight and until they would shut down?
And Ms. Byrd, actually, we have approached during the break, the other side about an earlier time, and I think they're amenable, but they haven't suggested another time yet. But my understanding is that they can shut down a little bit earlier, but we need to find out from them what they think is possible.
Okay. Well, I was just wondering if Mr. Sultani had any opinion as to whether or not there was anything that he knew of that would not allow that to happen.
My understanding is they cease operating, I think it's 4:30 p.m. daily, I think earlier on Fridays, and that they don't, that's my understanding of their operating hours.
Okay. So they're ending operation at 4:30 anyway. Okay, thank you.
Senator.
Right, Mr. Sultani, give credit to the district. You're truly an expert witness. You convinced me that for sure. And you not only know what they do at that site, how they do it, and why they do it, you understand the complete operation of that facility. Seems to be that way in any case. That being said, and being the case, it's very difficult for me to understand why you would pray ignorant to almost any question that might be asked relating to that facility. Now, let me just ask you this question then. On July 2nd, 2013, here we go. It says Anaplex Corporation.
Exhibit number.
Exhibit,
Look at the tab.
in the front. Oh, yeah, I'm sorry. Exhibit number 5.
Yeah.
Did you write that notice of violation?
Yes, I did.
And when the year did you write it?
If you look to the lower right-hand corner.
No, upper right-hand corner.
Yes, in the upper right-hand corner, the date of violation is listed as July 2nd, 2013.
Yes.
That was for the violations alleged in this notice of violation, that was the earliest date of violation for any of these violations that were detected. This document was issued.
Stop there. The earliest date that any violation was detected. So there are other violations that were detected at that time at this site?
If I may explain, I don't know is page 2 of this.
I don't have it.
Yeah, I don't think we.
Okay. If you look in the upper right-hand corner, it says page 1 of 2 on the notice of violation. There's actually a second page to this violation. Count number 6 of this notice of violation is a violation of a District Rule 1147, which pertains to process heaters and ovens. What we found in this, in the course of my inspection, is that there is an oven on site at the facility. It's used to dry parts that have been sprayed. The oven is equipped with a natural gas burner. The burner, we have a rule here at the district, Rule 1147, in order to reduce the emissions of nitrous oxide, which is a smog component used for smog formation. Beginning on July 1st, 2013, Anaplex was required to demonstrate compliance with our NOx limits for ovens. So they had not demonstrated compliance for that oven. Therefore, on July 2nd, 2013, they were in violation. The equipment unit, it doesn't pertain to hexavalent chromium. These are other violations. So that's why the date of violation is listed as July 2nd, 2013. It doesn't pertain to the nuisance ticket or these other violations. It deals specifically with that oven that's a non-compliant oven.
It says right there on number 1 on that page, 1 of 2, talks about the violation. They had no permit. You have listed hexavalent chromium being emitted.
There are 6 different violations being alleged on this document, and not all of the violations began on July 2nd, 2013. Only one of the counts we allege began on July 2nd, 2013.
More importantly, it's to me, the district knew about it at that time.
Ms. Broussard?
Just to clarify, what was the date of inspection that resulted in this notice of violation?
There are 6 different counts alleged in this notice of violation. The earliest inspections occurred on October 26, 2016.
2016. So the date of July 2nd, 2013, that doesn't respond to, or it doesn't relate to an inspection date. It's just you're relating back a violation. Is that correct?
It relates to an inspection of records. We were looking at the records, and they were beginning on July 1st, 2013, they were required to demonstrate compliance for their oven. So looking at they had not done so. So beginning on July 2nd, they were in violation.
But it was retrospective.
Exactly.
You went and you first inspected in October of 2016, and you retrospectively looked back at the records back to 2013. Is that correct?
That's correct.
Okay, so it's not that you knew about the violations in 2013, they just dated back to that date.
Exactly.
In fact, he was not the inspector for the facility in 2013.
But the records show that a violation existed at that time. The records showed that.
That the lack of records indicated a violation, I should say.
Well, you didn't look at any records before you fill out this document? I thought you said you referred back to the records.
We asked the facility, we asked Anaplex to demonstrate compliance. They were required to perform a source test or some type of test. They had not done that. So the lack of a record indicated a violation.
The lack of a record caused you to write this statement. That's a pretty strong statement for lack of a record. Never mind, Mr. President.
Mr. Soltani, the respondent was responsible for having the permit as of July 2013. Is that correct?
The equipment was already permitted. Rule 1147 required that permitted ovens demonstrate compliance with the emission limits in Rule 1147.
And it was that failure that was the violation.
That's correct.
Okay. So the district didn't have to have any record. It's that the respondent failed to produce compliance information.
That's correct.
Ms. Byrd?
Every time we get into one of these, it just brings a smile to my face because the district has a different way of documenting notices of violation. I used to write notices of violation, and we wrote them for the day that it occurred, but the district has a different way, and so this always serves as a source of confusion. But if you had, and I'm just going to ask one question, if you had separated the violations that you observed on that October 26th date, and you separated 1 through 5, and then you separated number 6, which we don't see. On the one that you would have written for that number 6, that would have the data violation of 7/2/2013, correct?
That's correct.
If you only wrote 1 through 5, it would have a data violation of what? 10/26 or the 11/29, one of those dates.
There are so many violations here, it's a little difficult to parse that, but I can tell you that based on personal observation, item number 2, I observed air sparging taking place when electroplaying was not occurring on November 16th, 2016. On that date, that's when I observed that issue.
And the others? Were they on you said you were there 10/26?
Yes, my first inspection, I was there to conduct the quarterly inspection on 10/26.
Okay.
2016.
So 1, 3, 4, and 5 would have been observed on 10/26, or they would have had a date of 10/26?
They would not have had that date. They would have had a different date.
Based on what?
The allegation of nuisance.
So you would have to go back for every single one of these, just like you had to go back for that oven that was in violation of 1147.
That's correct.
And so each one of those,
Each violation was an independent incident.
and so each one of those would have a different date. If you wrote them all, let me just quickly, if you wrote them all separately, each one would have a different date of violation up here in the corner, right?
Exactly.
Okay, thank you.
Mr. Soltani, how long has the district been conducting quarterly inspections at Anaplex?
I'm not exactly certain. I don't know when we began our quarterly inspection program. I've been an employee of the AQMD since April 2015.
Do you know, as of April 2015, when you started with the district, if the district had a quarterly inspection program that included Anaplex?
My understanding is yes, Anaplex was included in our quarterly inspections.
As of April 2015 that you know of, and so it may have existed beyond that.
That's possible, yes.
And so the question arises with quarterly inspections starting, we don't know when, why this wasn't caught, why the July 2nd violation was not caught until late last year. You don't know the answer to that.
I'm sorry, I don't.
I have some other questions for you. Based on your inspection, how long had the respondent been using chromate paint in equipment that wasn't permitted for that?
We have, I reviewed documents submitted by Anaplex to the district in the form of AER reports, annual emission reports that are submitted to AQMD. Anaplex reported in their reporting year 2014 and 2015 that they had been spraying chromates at their facility.
In violation?
Which would be a violation of their permits.
Some of the district regulations are difficult to understand, others are absolutely clear. Is it clear, reading the rule, that they needed a permit on equipment that they did not have permits for?
I think our permit to operate that we issued to Anaplex is, the language is very clear. I don't think there was any confusion that they were not to be spraying compounds containing chromium. But that's my reading of it. I think it's very clear.
Do you know if Anaplex has a individual who has primary responsibility for compliance with environmental regulations?
In my inspections, I've been referred to Carmen Campbell, president, for any compliance inspections and documents. Prior to a few months ago, Anaplex employed a consultant. Gentleman's name was Bernard Butch Griffiths with, I believe his company's name was called Cast Metal Services. So they had retained an outside consultant to assist with compliance matters.
He's no longer there.
My understanding is they now retain a new consultant for environmental matters.
You spoke about a confrontation with David Wong. Did he in any way prevent you from carrying out your duties?
I was able to complete my inspection after the confrontation and profanity, yes.
You testified that using the XRF device that you found significant levels of total chrome on some public surfaces. What did you mean by significant?
I should explain that this is a relatively new device at the district's disposal, and we have been using it. It's primarily used by our burn program for evaluating, my understanding is grape stakes for the presence of arsenic, but its use in the toxics and waste management group is relatively new. So this is one of the first times we've actually used it. What we did was we had evaluated some surfaces that we presumed did not be evaluated can be contaminated with chromium, and we detected levels in the 50 to 100 ppm range for total chromium. And then near the closer we got to Anaplex's facility, we started getting higher and higher numbers. If I remember correctly, the highest number we received was 6,000 ppm near Anaplex, which was significantly higher than the background control readings that we had collected.
And this included both upwind and downwind?
The unit does not measure air, it measures
No, I mean,
solid
the samples
surfaces.
you took, the testing that you did was both upwind and downwind of Anaplex.
If I remember correctly, we started north of Anaplex along Garfield Avenue and walked south right in front of Anaplex. Then we made a right turn heading westward along Madison Street, and we're checking surfaces that were adjacent to Anaplex, and then continued westward on Madison Street to Texaco. So we started north of the facility and then proceeded west of the facility, upwind of Anaplex, upwind of the prevailing wind.
And what did you find?
We found elevated levels of total chromium adjacent to Anaplex's property and significantly lower levels the further away we got from Anaplex's property.
Thank you. Board members, any questions? Senator?
Was there any residential property located in the area where it got more intensified chromium?
If I remember correctly, north of Anaplex's property is a facility, Aramark, which is a commercial facility. And to the west of their facility where we were doing these screening tests were other commercial and industrial businesses. When we were using the XRF unit, we did, around Anaplex, we weren't observe any residential facilities, or any residences
How
with the
far
XRF.
away from that area were their residents located, approximately?
From the testimony I heard earlier, there is a residence along Jefferson, is what I heard. I don't know from personal knowledge, but my understanding is to their east, to the east of Anaplex and to their north, to the northeast, there is a residence there. But I did not personally observe it.
Did you test that area?
We did not test that area.
Thank you.
You also mentioned you were denied, or someone was denied access to the roof?
On November 16th, 2016, the day of the screening test, I was present on site on that day as well with many AQMD personnel. At that time, my supervisor, actually senior supervisor, had inquired about access to the roof. And we were informed by Aniplex that Aniplex does not own the building that they operate in, that and that they referred us to the property owner in order to gain access to the roof. So we were effectively denied access at that time, pending permission from the property owner.
Did you seek that permission?
We did.
And did you get it?
We did. On December 9th, 2016, I and my supervisor inspected the roof of the two roofs of Aniplex.
Thank you very much. Mr. Senator?
Yeah. You heard the testimony today. You were in here all morning. And people crying and saying that their neighbors and friends have been subjected to chromium for a number of years for whatever reason, dying of cancer and things like that. So it's like a slow death, as they put it. Don't know why they die, but they do. Question is, don't you, in retrospect, don't you think it would have been nice if you tested that area while you're out there testing?
I'm sure all of us at the AQMD wish we knew about this sooner. I work for the Compliance and Enforcement Division, and our tools are our eyes and enforcement documents. And I from my very first inspection, I issued enforcement documents to Aniplex, and since we've issued several enforcement documents to them. But I think most of us here wish we this could have been resolved sooner.
Thank you. That's a human response. I like that. No more questions.
Any other questions for Mr. Soltani? Mr. Funderburg?
Yes, I have a couple of questions, few questions, but Mr. Soltani testified about lab results. I wanted to know if those were being, are you relying on your memory for that, or does the district plan on introducing those lab results that have these high readings for the XRF at all?
Oh, no, we weren't planning to introduce the evidence about
Even though even though he's relying on those, you're not introducing the district's
no, our plan was not to introduce evidence about the XRF readings.
Okay. If I could take a quick bathroom break in about 10 minutes, Mr. Chairman, I can proceed questioning. I know we're trying to get out of here, but.
We'll reconvene at 3:40.
Thank you.
We're back on the record.
Mr. Saltani, before the break, had indicated that he did have a document indicating these XRF readings, so he was going to, well, he has retrieved them. So we can introduce that as an exhibit if, it'll be Exhibit 20, I believe.
Yes. Mr. Wong has distributed a, well, it looks like a map titled Paramount XRF Readings 11-3-16 by A. Soltani and M. Pua, Unit Number 1. We'll make that exhibit number 20. Did you wish to?
I just wanted him to identify the exhibit. Mr. Saltani, would you please identify Exhibit 20 and describe what it is about?
Yes, exhibit number 20 is a diagram that I produced with readings derived from the district's XRF unit. We used it to measure total chromium levels along in public areas, and the unit of measure is parts per million, ppm.
Okay, thank you.
Mr. Vandenberg, any questions for Mr. Soltani regarding the exhibit?
I actually have questions regarding all of his.
All right,
if
go ahead.
The board is finished questioning him. Thank you for your service and congratulations, Mr. Soltani. What I just want to do is go back a little bit over the testimony he gave to Mr. Wong had, and just so that I'm clear, I wanted to fast forward from the time you started. You started at the district in October of 2015, is that right?
I started as the inspector of Aniplex in October of 2015. I started with the AQMD in April of 2015.
Okay, and prior to that, did you work in the San Diego Air District? Is that correct?
Yeah, for 4.5 years, I was an air quality inspector with the San Diego Air Pollution Control District.
Okay. And so going fast forward to the inspection that you had in March that led to the notice to comply, I believe, that you testified about. So that inspection, what gave rise to that inspection? Was it the prior notices, or was it this a Rule 1469 quarterly inspection?
I'm assigned to inspect Aniplex quarterly. So this was the quarterly inspection, and also was the annual inspection of the facility.
Okay, and were those inspections, so those inspections were for chromium under Rule 1469, but also all the other things that the district regulates at Aniplex, is that correct?
That's correct.
Okay. And when, in March, in February and March of 2016, earlier this year, did you notice that Aniplex's emissions had been misstated in any of the filings that Aniplex had made?
Are you referring to the AER reports?
Yes.
The AER report that Aniplex submits to the district is normally not a document that Compliance and Enforcement Division reviews. That is used. My understanding is that document is used primarily for fee collection and is almost like a billing document to determine what the annual emission fees are to be paid by the facility. This This is the first time Anaplex is the first time I'd actually reviewed an AER report. So that's normally not a document we review.
And was the person that you dealt with from Anaplex related to the questions you had about the AER report, was that Butch Griffiths or Bernard Griffiths from Cass Metal Services, or was that Ms. Campbell?
I had not, my copies of the AER reports came from AQMD personnel. I hadn't asked Anaplex personnel any questions regarding the AER reports in March of 2016.
Mm-hmm. And you said that Mr. Griffiths had been the person prior to 3 or so months ago that you had been dealing with at Anaplex. Did you, when was the last time that you dealt with Mr. Griffiths on behalf of Anaplex?
If I remember correctly, in November of 2016, Mr. Griffiths had hand-delivered some documents to AQMD that the AQMD had requested, and he had left me a voicemail letting me know the documents were here. That was my last, well, I take that back. I received a few emails from him shortly thereafter, but those are the last interactions I had with Mr. Griffiths.
But when you dealt with Anaplex in your prior visits, prior to November, was it Mr. Griffiths who would come for the inspections that you did, or was it Anaplex personnel, or a combination of both?
Usually, when I arrived on site, my point of contact was Carmen Campbell, president. My understanding is that Mr. Griffiths was only on site 1 day a week. I think it was Tuesday. He was on site on Tuesdays, and on Tuesday, November 16th, I met with Mr. Griffiths in person. The other inspections, if the day happened to fall on a Tuesday, if it wasn't on a Tuesday, then I don't imagine Mr. Griffiths was there.
Okay. And did Mr. Griffiths ever misstate or mischaracterize Anaplex's operations to you about the different types of chromium, that they handle at the site, or the types of dipping or anodizing that they do?
In my inspections, I have found several inconsistencies between Mr. Griffith's accounts and their accounts, and even between Anaplex personnel. I'm trying to think of one in particular right now, but we have had we've detected some inconsistencies at Anaplex between different personnel.
Right. Okay. And when was the last time that you visited Anaplex?
The last time I was on site was I believe on Tuesday, January 3rd, and I was on site with Inspector Minsu, and he and I were on the roof at Anaplex.
Mm-hmm. And have you spoken with the fire department, LA Fire Department, about their recent inspection at Anaplex of the roof and other issues in the past couple of days?
I haven't personally spoken with LA Fire Department personnel. I received an email forward from LA Fire, but I've not personally spoken to anyone from LA Fire.
Okay. So you're unaware of the report where they claim that Anaplex is in full compliance with the regulations that the fire department has, not that the air district has, but that the fire department has?
I believe I received a forwarded copy of an email, and I think, I don't have the email here in front of me, but I believe it was a summary report from LA Fire.
Mm-hmm. Okay. As to the XRF measurements that you took on November the 3rd of 2016, I believe it's Petitioner's Exhibit 20 for the hearing board's approval. On Minnesota Avenue, there's you picked up, and I'm assuming that this is, by the way, for the XRF, this is not airborne particles that you're picking up. This is solid, what would be considered quote unquote solid waste, correct?
We were not measuring waste. It can be used to measure waste. The XRF unit, it's approximately the size of, I guess you say, about a loaf of bread, and is a handheld unit that uses it projects X-rays onto a solid surface, and then based on what's reflected back, analyzes what the surface is made of. It cannot be used for, it's not used for air or for liquids, but it's used for solid materials. Mm-hmm. And we used it on sidewalks. We were analyzing public sidewalks along that route, but it could be used for waste or other solids.
Mm-hmm. And the 12,000 reading that you have on Minnesota Avenue, 12,000, you testified that was ppm, correct? What facility is that in front of, or and to what did you attribute that?
The readings along Minnesota Avenue were adjacent to Aerocraft Heat Treating Company.
Mm-hmm. That was a compound question. What did you attribute that to Aerocraft, or did you attribute it to another facility that you had visited? The 12,000 reading.
The 12,000 reading was adjacent to Aerocraft, and I have also inspected Aerocraft, and believe that the district has also entered in a stipulated order for abatement with Aerocraft to control hexavalent chromium from their facility as well.
Right. And have you seen the laboratory reports for the readings that are given here, or is this just a summary of the laboratory reports on this map? I'm sorry, on Exhibit 20? On Exhibit 20, yes.
The XRF gives readings immediately on the spot. It uses a 60-second exposure time. It was programmed to set to 60 seconds, and the readings from the unit were recorded by Inspector Pua directly on the spot. It's an instant analysis, you could say.
Okay, and you said the readings were for total chromium, correct?
That's correct.
And the device is not able to speciate to trivalent or hexavalent chromium, correct?
That's correct.
So you don't know whether that was hexavalent or trivalent chromium, correct?
That's correct.
Are you familiar with EPA method SW 846, Mr. Sultani?
I'm sorry, I'm not familiar with that test method.
SW is for solid waste, and it's a standard test methodology for digesting and running what's called the toxicity characteristic leaching procedure on solid waste. You're not familiar with that?
No, I'm not.
Okay. And are you familiar with test methodology for solid waste under California law for what's called the TTLC or the STLC?
I'm not familiar with that.
Have you been trained in sample collection for solid waste at all?
I've been trained in sample collection for more generally, not pertaining specifically to solid waste, but I am an AHIRA contractor supervisor trained in asbestos. Part of which is a 40-hour training. Part of our training deals with sample collection. I've also attended a US EPA training course regarding sample preservation and sample collection techniques. I've also attended several California Air Resources Board continuing education training courses where sample collection, chain of custody, and sample techniques are discussed. And I've been an air quality inspector for 2 different air districts for more than 6 years now, taking samples for enforcement purposes.
And when you say taking samples for enforcement purposes, are you taking samples of scrap metal that's laying on the ground, or are you taking samples for airborne particles?
Most of my sample collection has been collecting samples of asbestos. The AQMD is delegated by US EPA to enforce the asbestos regulations for Southern California, and we respond to complaints of asbestos concerns. And so I'd have to say through my career, most of my sample collection has been a collection of asbestos debris. We do not conduct destructive sampling of asbestos. We only collect debris that has been dislodged by construction activity. So it's primarily collecting waste off of the ground or off of public areas.
When you were at the Anaplex site, I know that you're an air quality inspector, but it sounds like you've also done some collection of solid waste. Did you ask the facility for the management practices for sweeping and house cleaning and otherwise for its stormwater pollution prevention plan?
I never inquired specifically regarding stormwater pollution. That's normally outside of our purview with the AQMD. I believe the CUPA or other environmental regulators, deal with stormwater issues. The one time that I did have an interaction with Anaplex personnel was on Friday, December 30th. I and another inspector, we collected samples of rainwater runoff from the roof, from 2 different roofs at Anaplex. And at that time, we had asked Ms. Campbell if she wanted a split of our sample. And she reported to us that she had already taken her samples of stormwater. That has been my only interaction regarding stormwater sampling by.
Have you received those results for stormwater, have you received those results for December 30th for the roof water?
Yes, the district does have the results of that water analysis. And my understanding is that one of the 3 samples measured, I don't know if I have the result here, but it was at 1 ppm hexavalent chromium. One of those samples was at 1 ppm.
Are you familiar with the water quality objectives in the state general industrial stormwater permit that Anaplex is regulated by?
I'm not familiar with Anaplex's permits. I have personally taken some awareness training courses. My previous employer was the County of San Diego, and all county employees were required to take it once a year awareness training, so that if we detected possible discharges or illegal discharges, that we were to report them to and make an interagency referral to the other agency. But I'm not familiar with anything regarding Anaplex specifically.
May I interrupt here and just inquire as to why we're asking all this stuff about water quality? It is an important concern, but we're here about the air and not water quality.
The Stormwater Pollution Prevention Plan has best management practices requirements that directly overlap with the requirements in the stipulated abatement order related to housekeeping management practices, et cetera. The State Water Board conducted an inspection in December and gave Anaplex a clean bill of health. I'm getting to the fact whether Mr. Sultani's view of the dust and management practices at Anaplex, which was raised initially, is consistent with what the State Water Board views was stormwater, especially since the district used a test method for groundwater, processed water, and other to test the roof samples. So it's the reason that I'm going there, it's directly overlaps both with the stipulated abatement order as well as the management practices that Anaplex is employing and that are included in the A to Z list in the abatement order.
Seems we're going far afield, Ms. Prusek.
It seems it too, only because I'm wondering, is your aim, again, to dispute? I thought there was a stipulated order. Are you attempting to dispute the measures in the order?
Not at all. I actually thought that this was going to last like an hour and that the stipulated order was agreed to. We agreed to it, but evidently there have been some changes. There have been things that have been injected that we didn't think were appropriate, like the roof and the roof particles.
Let me stop you there. The roof, my understanding is we are going to bifurcate and have the roof separate. The only reason why we're going to introduce any testimony with regard to the roof is because the witness will not be available for 6 weeks.
So I'm trying to get my testimony in about the witness. I mean, is the witness going to be available when the roof is dealt with? The roof is clean, Anaplex cleaned it, and it's more a matter of, I mean, it really shouldn't be subject to.
If the rest of your questions are with regard to the roof, I do not believe there was direct testimony yet on the roof issue. You could hold them and wait for the direct testimony.
Okay, I will. I have a couple of other questions, please. Mr. Sultani, Rule 1147, what is, you cited in your notice of violation that's dated July 2nd, 2013, that was served on November 29th, 2016, some violations of Rule 1147. Can you be more exact about that and describe when that rule went into effect and whether you looked for any exemptions that might apply based on BTU output at Anaplex for the, I believe it's furnaces or the equipment that have that would be subject to Rule 1147?
I'm not exactly sure when Rule 1147 went into effect. I do know that Rule 1147 went into effect, the pertinent part regarding emission limits to the permitted oven at Anaplex on July 1st, 2013. On July 1st, 2013, Anaplex was required to demonstrate compliance with the emission limits in Table 1 of in Rule 1147.
Okay, did you ask Anaplex what the BTU output was for the furnaces that were at issue under Rule 1147?
Yes.
And what was that?
I have it here. In this way, if I may ask, we're not really pursuing violations of 1147 here, so I'm not quite sure why we're talking about 1147.
We're talking about 1147 because Mr. Sultani testified to it.
However, it's not relevant to the allegations being made in the petition, nor is it relevant to the order for abatement we are currently examining. I understand it was part of a notice of violation, but it is not part of this matter before us, unless you can explain how it is directly relevant. Plus, this board has no jurisdiction to consider disputes to NOVs.
I believe that the district is trying to, I'm trying to dispel the public of the impression that Anaplex was not falling asleep at the wheel here. And I believe that that's the impression that's left. Anaplex agrees to do the agreement, but I just want to make sure that if the district is bringing this up in the context of its case, that it's clarified as to what the inspector actually believed. The district shouldn't have brought it up, the 1147 issue in Sultani's testimony.
What's that? The board, I think the board brought it up.
Yeah,
But
we did.
We did. However, again, it is not our jurisdiction we don't have any jurisdiction to hear disputes over NOVs. If an NOV is submitted to us, we can consider it. In this case, it's not really direct evidence if it's of 1147. However, we're not in a position to hear disputes over whether the NOV was correctly or incorrectly issued.
Senator.
Mr. Chairman, on the advice of council, I voted to listen to the argument made for the roof. But if it's going to be discussed in any detail, it would be my understanding that you wait until it's put on the table, and once if it's on the table, then you've got a right to cross-examine regarding this issue at this point in time.
I understand that, Senator, and I'm not.
You have a right to. You do.
Yes, sir. I understand that, and I'm not going to ask any more about the roof.
So it's not relevant to this case. So say what you want to say, and then you'll be excused until you come back in 6 weeks.
Any other questions for Mr. Soltani?
Yeah, I have another question for him. Not on this.
First of all, Mr. Vandenberg, you're done with the questions for Mr. Soltani?
I had one other question for you, Mr. Soltani. The 6,000 ppm reading that you found at Anaplex, where was it? Okay, you testified that you found 6,000 close to Anaplex, or was it a block away from Anaplex? I just want to.
I was mistaken. I didn't have the diagram in front of me at the time. The highest reading that I measured adjacent to Anaplex's property was 3,813 ppm, and that was located along Madison Street on the southern edge of the Garfield Avenue building of Anaplex.
And 3,000 ppm, just, I mean, I'm not a mathematician, but what is that by? Is that 0.3% or 3% or?
I believe it is would round up 0.04% total chromium. This number reflects total chromium, not hexavalent chromium.
Okay. No further questions.
Senator.
Mr. Soltani, when the district dispatched you to that site to inspect, were you advised and informed that you're going into an area that was highly contaminated or may have been highly contaminated?
I was not aware of contamination at the time of my first inspection.
Were you advised, or did you ever think about wearing any protective gear when you went into the place?
We always think about personal protective equipment whenever we inspect a facility. When I inspected Anaplex, I wore safety shoes and eye protection on my first visit. Since then, depending on where we have inspected, we have greatly increased the amount of personal protective equipment that we wear. For instance, when I and my supervisor inspected the roof of Anaplex, we wore, in addition to that, we also wore a full Tyvek suit, full face respirator, and gloves while we were on the roof of Anaplex.
Was any Anaplex employees on the roof with you?
We were escorted by an Anaplex employee on our December 9th inspection.
Did they wear gear as well, protective gear?
He had with him a half-face respirator, which I don't remember he was wearing, but he had it with him. He did not have the same level of personal protective equipment that my inspector and I were wearing when we were on the roof.
Right. You've been an inspector. You did a darn good one, too, as far as I believe. And when you observe things that's displayed at the site, there are certain safety features that are required, even by OSHA, placed on the wall. Did you see anything like that?
I believe I may have seen a type of like a poster for that all employers have to post regarding minimum wage laws and protection of that. I think I may have remembered seeing something like that while I was there on site.
But nothing for safety?
I don't remember regarding safety.
Nothing posted? Thank you.
Any other questions?
Mr. Chairman, I had one, just to follow up on.
Just one.
Yes. Are you aware that Anaplex had several OSHA inspections in the month of December, and have you received the results of that inspection?
I wasn't aware of that.
Thank you.
Okay.
I think Mr. Wong is going to ask questions with regard to the roof.
We're going to start with the roof.
And that, may I ask, is it possible to confine, given the time, Mr. Saltani's, your questioning of him to only that which no other district staff employee can answer in his 6-week absence?
Well, other people might be able to, but I think Mr. Saltani is the best person because he has quite a bit of, he has a PowerPoint presentation, so maybe we can go through that. Let me submit as exhibits, Exhibit 21 and 22.
Question to our attorney. Do we have jurisdiction over this roof at this point in time?
I had ruled on the objection to hearing any evidence with regard to the roof that the petition covers all nuisance with regard to chromium-6 emanating from this facility, and that would include the roof.
Then both sides can talk about it.
I think that's what we're going to do right now.
This thing, because I don't.
We have, okay. We have received 2 documents. One is a monitoring and analysis report. It is laboratory number 1634805-01 to 13, and we'll mark that as exhibit number 21 for the petitioner. We have also a PowerPoint presentation, which we will mark as exhibit 22. The time is 4:10, it's 4:12. It's beyond the time that this board normally adjourns. We will continue until that point when I lose a quorum, and at that point we'll have to adjourn. I would say for those board members who are unable to stay until the very end, that this matter, as you all know, is being webcast, and the recorded webcast can be viewed so that you'll be up to date when we return, which at this point is likely to be Tuesday of next week.
My question, how much time will the petitioner need to present this PowerPoint? Because this is a lot of work here.
Yeah, I think we're having some technical difficulties here, and so
Well, then maybe we ought to put it off.
put what off?
Mr. Soltani will not be here.
Right, so we just need to figure out how to get in, I'm sorry.
Mr. Wong, there's another device that that can be used,
Oh, why don't we use that?
and
Yeah,
we would appreciate
maybe,
that the testimony be as concise, succinct as possible.
okay. Okay, Mr. Saltani, would you please go through your presentation on your roof inspections?
Okay. Okay. Okay, on December 9th, 2016, Okay, on December 9th, 2016, I was accompanied by my my supervisor, Garrett Kashita, and he and I inspected the roof of Anaplex. And I returned to the roof. I was accompanied with Inspector Min Soo on January 9th, 2017. And this is a diagram of the area around Anaplex. Anaplex consists of two buildings that are side by side that you're actually able to walk from one roof to the other, right here, and then has a separate structure here along Madison Street. So I may have referred to this as the Garfield Avenue building, and then this as the Madison Street building in these reports. You switch that? Okay. I'll switch to the PowerPoint. Okay, on December 9th, 2016, as I said, we inspected the two structures that comprise Anaplex. One is the Garfield Avenue building, and the second is the Madison Street building right here. We had first inquired for access to the roof way back in November. On November 16th, 2016, we had asked for permission to inspect the roof. We were if you can see, these images are from Google Earth. We had observed discoloration on the rooftop, and we were curious to find out what was on the roof. My understanding is that based on other facilities, metal finishing facilities in Southern California, that residual material could be a contributor to hexavalent chromium emissions. So we had asked for permission to go on the roof to make observations and take samples beginning on November 16th, 2016, and we were granted consent on December 9th, 2016. This is a diagram to try and highlight some of the important points. Anaplex's anodizing operations take place here in this area, and Anaplex's plating operations take place roughly in this area of their building. In addition, Anaplex has permits with the AQMD for 4 paint spray booths. The paint spray booths, paint spray booth number 1 is located here in the Madison Street building, and it is used, my understanding is primarily for oversized parts. It's not used very frequently, but it does have a permit that forbids the spraying of chromates and has an exhaust stack that escapes here to the roof. The other 3 paint spray booths that Anaplex operates are located in this area generally. This right here is the exhaust stack for paint spray booth number 2. Paint spray booth number 2 is used primarily for applying primers, including epoxy primers that I'd previously noted had contained hexavalent chromium. And paint spray booths 3 and 4, their exhaust stacks are located here to the north of paint spray booth number 2. And my understanding is those are used, at least they currently are being used to apply different top coats, and not for primers. And in the past, I had detected that we detected the presence of hexavalent chromium. We had detected the presence of hexavalent chromium in the exhaust filters in paint spray booth number 1 and in paint spray booth number 2. That was the notice of violation that we issued for violations in March 2016. And this is a chronology of the events regarding Anaplex's roof. On December 9th, I was on site, and we took samples and photographs from Anaplex's roof. Later, we discovered that on December 14th, Anaplex began cleaning the roof. It was being cleaned by Anaplex personnel. We found this out after the fact that was taking place. On December 15th, 2016, Anaplex had created a hazardous waste manifest for the materials collected on the roof. Later, we received a copy of that hazardous waste manifest. On December 29th, 2016, the results of our sampling, we received those back, which showed some elevated levels of hexavalent chromium for the samples that we collected on the rooftop. On December 30th, I was on site. I had collected rainwater runoff in the morning on that day. Another inspector, Inspector Minsu, was on site along with Coupa staff, and they had inspected the roof and had discovered what they deemed improper cleaning of the roof. On January 3rd, on Tuesday of this week, I returned to the roof along with Inspector Minsu, and we took additional photographs and took 2 additional samples of material from the roof. So this is an example of what we saw on the roof. On the left is what was as how some of the roof appeared on December 9th. On the right is a photograph from January 3rd. This is the so Anaplex's facility is equipped with several exhaust fans that draw air from the facility and shoot it upward. This was the exhaust fan that was located very close to the dichromate seal tank. The dichromate seal tank was tested by AQMD personnel and was determined to have levels, I believe there was 688,000 nanograms per cubic meter of hexavalent chromium. So this was an exhaust fan that we were very interested in to find out if there was any hexavalent chromium on or around this exhaust fan. Between December 9th and January 3rd, a lot of this loose debris, as you can see, there was a lot of loose debris on the left. On the right, all that debris had been picked up and collected, and the roof fan enclosure had been painted. This is a detail of the fan enclosure. When I was on the roof on December 9th, we had collected both loose debris samples on the rooftop and also had taken scrapings off of the grill of this fan enclosure for sampling. I don't have the, well, here's the.
Mrs. Saltine's referring to Exhibit 21.
If I'll go back, this loose debris located right here next to the fan, we took a sample of that material, and that material tested at 7.5% hexavalent chromium, or another way, 75,000 ppm hexavalent chromium. We also took scrapings from the exhaust fan. Here's the detail of the fan. We took scrapings of from that fan enclosure, and that material tested at 0.48% hexavalent chromium, or 4,800 ppm hexavalent chromium. 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 4,800 ppm hexavalent chromi This is a detailed photograph of the loose debris found near the dichromate seal tank exhaust fan that tested at 7.5% hexavalent chromium. It tested at 7.5% or 75,000 ppm. It appeared that most of the loose debris, here's a photograph of some loose debris that we found on December 9th. This loose debris here, we tested this and it came back at 2.5% hexavalent chromium or 25,000 ppm. Most of this debris had been removed. When we were there, we found very little debris in that same area. We did take a sample of it. We also offered a split sample of it to Aniplex, and they received a split sample of this material. This material has been submitted to the district laboratory for testing. I don't believe we have the results yet for that material. All right. This is a photograph of 3 of the exhaust stacks at Aniplex. This exhaust stack here is exhaust stack number 2. This is where the previously in March of 2016 we had taken samples of the filter media and we detected the presence of hexavalent chromium. This is the exhaust stack where the overspray from that paint spray booth would be emitted. These two, stack 3 and stack 4, were not used for epoxy primer application, but we did take samples. We took scraping samples from inside of the exhaust stack and also took samples of loose debris. Every one of those samples showed the presence of hexavalent chromium on the exhaust stack or near the exhaust stack in the form of loose debris. And this is a more detailed shot of the exhaust stack number 3. Here's a close-up view of exhaust stack number 3. You can see here there's a significant buildup of dried overspray over many years of operations. In addition, there is a greenish coloration of this dried overspray. Greenish overspray is usually indicative of chromate-containing primers. That's green is a red flag for us for chromate. And this is another photograph of exhaust stack number 3, also showing the same greenish discoloration, usually that you would see for epoxy primers containing chromate. Here's a photograph of exhaust stack number 4, and on the underside we can see a significant buildup of dried overspray. Exhaust stack number 4, this dried overspray measured at 0.67% hexavalent chromium or 6,700 parts per million. Here's another detailed shot of the inside of that exhaust stack. Both before and after cleanup. So this material is still present on site, and it measured at 6,700 ppm. Exhaust stack number 2, both on our December inspection and our January inspection, shows a dried overspray buildup. The scrapings from exhaust stack number 2, the overspray measured at 2.6% hexavalent chromium or 26,000 ppm. And we can see the greenish discoloration here.
26,000 or 2,600?
That is 2.6%
And that's
or 26,000 ppm.
26,000.
And this is exhaust stack number 1. This is the exhaust stack on the Madison Street building. This paint spray booth, I had previously taken samples from the exhaust filters, and they had in March of 2016, and they had shown the presence of hexavalent chromium then. This material tested at 4.1% hexchrome or 41,000 ppm hexchrome. And you can see the greenish discoloration. Here.
Just to clarify, so there was no cleaning of stack number 1 was there?
It appears that the material that we saw on December 9th inside of the exhaust stack is still present and was still present on January 3rd, that dried overspray inside the exhaust stack that measured at 4% hexchrome. Here's some better photographs showing the detail. Here on January 3rd, we can still see the inside here is festooned with dried green overspray. In addition to that, we also found greenish colored debris near the. This is the escape for the rainwater runoff where the rain gutter drains. Right near that, we can see some greenish debris. This was on the Madison Street building, and this was on January 3rd after the Anaplex had been on the roof to attempt to do cleanup. And while we were there on January 3rd, we talked with Anaplex personnel and asked them how they performed the cleanup. They reported to us that they had used they'd called it a HEPA vacuum. The term HEPA is thrown around quite a bit commercially as a selling point. However, for the purposes of the AQMD, we would not consider this a HEPA vacuum. In asbestos removal, HEPA vacuums are actually required to be registered with the district, and so we're familiar with industrial grade HEPA vacuums. This is not a HEPA vacuum. This is a shop vac, wet dry vac type vacuum that you would find at your local Home Depot or hardware store to be used, for cleaning up sawdust or those kinds of loose debris you'd see in a shop. It's not what we would consider a HEPA vacuum. What they showed us was they had purchased this filter for their shop vac, and the filter uses the term HEPA. It calls it HEPA material, but it would not meet the standard for what we would call a HEPA vacuum or HEPA filter. It's kind of just a selling point for the product. And in fact, all around the vacuum, we noticed green dust affixed to the vacuum cleaner that was used. There's pulverized green dust along the wheel, along the clamps where the vacuum is held together, and especially here, there's a very fine greenish powder near the exhaust stack, the exhaust vents for the vacuum, which I believe is evidence that the filter media was not capturing the greenish debris that was vacuuming up.
Thank you. Let me ask you some follow-up questions. Oh, I'm sorry. Thank you. Let me ask you some follow-up questions. In your opinion, in terms of the cleanup hexchrome, would the district have allowed the use of this shop vac as a means of cleaning?
The district only, my understanding is the district only registered HEPA vacuums in the context of asbestos work. That being said, this is not the equipment that I would have used to clean up this type of material. In fact, this type of cleanup may have exacerbated the situation. It's well known in the asbestos industry that improper cleanup techniques can actually make a bad situation even worse. By pulverizing material and re-aerosolizing material and putting it into the air, we can see from this photograph that green debris is now green powder and is covering the outside of this vacuum. It's very likely that this green powder was present in the air and exposed the workers who were using it and the ambient air around it.
You had indicated in this slide presentation that it was determined that they started to clean up on December 14th, 2016. Is that correct?
Yeah, that's my understanding. We'd received some information from the LA Fire. They had, the email that I had received forward from them indicated that was the date that they had started cleanup.
And, let's see. We have some monitoring data somewhere. Oh, right. Turning to the exhibit that you had provided. Oh, you don't have December 14th. The district will now submit another exhibit on various hexachrome readings. I guess it's number 21, I believe.
22,
Oh, 22, sorry. There's a count here.
23, what's 22? Oh, yeah, 23. Mr. Wong's distributed a table titled Hexavalent Chromium Monitoring Results, nanograms per cubic meter. We'll mark this as exhibit number 23.
Thank you. And again, they had done the cleanup on December 14th. Could you read the reading on December 14th? I believe it's for monitor 15.
Yes, it appears that the AQMD had an ambient air monitor in place on Wednesday, December 14th, which coincides the day of the cleanup that was reported by Anaplex. Site number 14, known as Garfield Madison number 2, reported a reading of 10.00 nanograms per cubic meter of hexavalent chromium.
Thank you. No further questions.
Mr. Vanderberg.
Yeah, Mr. Sultani, thank you. The test method that you were using to determine the parts per million for the roof material, did you use the same test method for that?
Mr. Saltani is not in charge of actually doing the analysis for the testing.
The collection of the roof material, did you use the same collection methods for the roofing material? Either, like when for instance, when you had material on the roof, did you scrape it and was care taken not to get the roof material also?
We did a combination of two methods of sample collection. In both cases, I had used a sample collection spoon so to not make direct contact with the material being sampled. We used a unique spoon for each sample, and in fact broke the spoon and put it in the sample collection container. For the samples labeled as loose debris, I used a spoon to scoop the loose debris and collect it in the sample container. For the scrape samples, I used the spoon to take scrapings from either the metal grill around the exhaust fans or the dried overspray in the exhaust stacks on the roof.
And one of the reports I remember reading reported that there were hard chunks of something on the roof. Where was that located? Where did you find that on December the 9th?
Let me see if I have a photograph of it. We had observed adjacent to the dichromate seal tank, solid debris located to the east of the fan, so essentially downwind. The prevailing wind would come comes from the west to the east. So it appeared that there was debris here on this side of the exhaust fan. We collected solids here. We also collected solids here. This, unfortunately, I don't have an establishing shot for this debris, but it was located similarly downwind of the fan enclosure that was above the chromic acid anodizing tank. So there was debris there. We also collected debris near the exhaust fan above rinse tank number 41. So we took 3 solid samples from the roof surface near the anodizing area. We also took dried solid samples near the foot of some of these exhaust stacks.
Okay, I'm trying to speed things up here.
Sorry.
No, thank you. Was there anybody else with you so that if you're not available and we have other questions about it, was there anybody? I think there were other people at the district with you. Right?
On December 9th, 2016, I was accompanied by my supervisor, Garrett Kashita. Also present was Bill Welch, air quality engineer for our source testing group. From Anaplex's side, Mr. Salvador Posadas, the maintenance director, was present on the rooftop. On January 3rd, I inspected the rooftop with air quality inspector Min Soo, and in regards to Anaplex, Mr. Posadas was also present, as well as David Wong, Vice President of, I believe his title is Vice President of Quality. He was present on January 3rd.
And you said that you had not seen the fire department report from which is the CUPA lead agency, correct?
I hadn't spoken, I think you asked me if I'd spoke to them. I hadn't spoken to them, but I had received a forwarded email with a kind of a summary report from LA Fire.
Right. And was that from January 3rd, or what date was that from? Do you recall?
You know, I'm sorry, I don't have the email in front of me. If I remember correctly, it referenced, though, that a cleanup taking place on December 14th. And that's what I remember from that email.
The only reason I mention it is that on the timeline that you had, I don't have it in front of me, the timeline that you had, you mentioned on December 30th, I think, that there was a CUPA problem. And the CUPA is the fire department, correct? And I'm just trying to figure out what the problem was that the CUPA identified if they did this report on January 3rd. So I just want to get the timeline correct while you're here.
I was present in the morning at Anaplex on December 30th, Friday, December 30th.
And that was the day that it rained?
There was a rain event on that day. I was directed by AQMD personnel to collect a water sample from the rain gutters at Anaplex. I collected the samples and submitted them to the AQMD laboratory for analysis that same day. Inspector Min Soo, who was with me at the time, stayed in the area, and my understanding is later that day he was on the rooftop with the CUPA, but I wasn't present for that.
Okay, so I guess I'm just trying to find out. The chronology that you had on page 3 or 4, you said that CUPA staff visited Anaplex to request immediate roof cleanup, only to discover improper cleaning had already been performed. And I'm sorry, in the chronology you said accompanied by SCAQMD inspector, CUPA staff visited Anaplex to request immediate roof cleanup, only to discover improper cleaning had already been performed.
I did not prepare this presentation.
Who did? And the only reason I'm asking, I just want to be able to speak to while you're on.
I'm not sure who prepared this presentation, but that's my understanding of that there was a CUPA inspection done in the afternoon of December 30th, 2016.
So if you were shown a document that contradicted that, you haven't been shown it, so you just don't know what that was for.
Yeah, I'm sorry, I don't have personal knowledge about that inspection.
Thank you, I'll stick with that. The particles that you tested, they seem, trying to just get some idea, that toward the end of your presentation, they seem more dust-like, like from the back, the HEPA vac, the green dust.
Are you referring to this?
Yes. The other part, some other particles seem to be more chunky. Are you familiar with the micron size that defines scrap metal?
I'm sorry, I'm not familiar with that.
Okay. All right. I think that we can follow up on this testimony with some other witnesses, but that's it. Thank you.
Mr. Wong, will the supervisor, Mr. Soltani's supervisor and Inspector Minsu be available on Tuesday?
I need to check on that. Let me, I can quickly find out. So we believe they should be available.
Seems to me that they can fill in the blanks on the rest of the, what we need to know. Any burning question for Mr. Soltani before he goes off on his new adventure?
Yes. Mr. Soltani, did you have to sign a waiver from liability to go on the roof? Did the property owner require you to do that?
I did not sign it. I don't believe I was required to sign a waiver, and I did not sign a waiver.
You don't know if anybody signed a waiver on your behalf for safety?
I don't believe so.
Okay, so, thank you.
Thank you. If there's no other questions, I need to ask if there's a member of the public who wishes to testify yet. I see none. Mr. Wong?
Yeah, at this point, I would like to move into evidence, exhibits 15 through, was it 23?
Any objection, Mr. Funderburg?
Any objections have already been stated for the record, so no further objections.
And I don't recall if he had a specific objection, an objection to the individual exhibits 15 through 23. For example, 15 is the proposed order. 16 is the list of exhibits. 22 is the PowerPoint.
Well, we're not objecting to the proposed order because we agreed to it. Just to put the vice chair these. I previously objected to anything related to aircraft on foundational grounds, and I made a standing objection to streamline things. It was overruled, and I stood by that. So that's anything that refers to aircraft that kind of was pulled into this proceeding. It's the objection. We're not going to make any more fuss of it other than putting it for the record.
In that event, exhibits 15 to 23 are in evidence.
Thank you, Mr. Chair.
Okay, we're going to continue this matter to Tuesday, January, what's Tuesday? 10th? 11th? To Tuesday, January 11th at 10th, okay, at 9 a.m. We do have another matter that morning that will start at 9 a.m., but we expect that it will be taken off calendar or continued, and so that's the reason we're asking you to be here at 9. Anything further? No other business?
Excuse me, Mr. Chair. One of our expert witnesses, Dr. Robert Schofield, who we listed on our witness list, is snowed in and may not still be available. But is there any way? How should we communicate with the hearing board about availability of witnesses?
With the clerk of the board, who will advise Mr. Wong and myself. Send him a snow shovel or...
Well, at least we got some snowpack for our drought problem. Thank you.
Okay. We're adjourned. Senator?
There's a question for board members' comments.
Yeah, it's on, down at the bottom. I asked if there was any further business. Go ahead. This is off, we're no longer on the Anaplex matter. We're just talking about board business.
And much we were talking about chromium and hexavalent chromium. There's a company called Hickson that was coming before us, and I know they were scheduled sometime in July, August, but we didn't see it. We were busy doing something else with the Sunshine Canyon. I think that I would suggest that we bring that back to us. There are a lot of people being affected by it in that neighborhood, and I think we should bring it back and take a look at it. That's number one. And number two, Lisa Canyon can be running out soon, and we have not addressed that health issue that they were supposed to be paying for. That has not happened. I'd like to see that agendized again also.
Well, we have Lisa Canyon coming back mid this month. This week? This month.
This month.
We have SoCal Gas coming back for a status report.
Okay, and will the issue of the health?
That will be one of the main issues.
Oh, very good. The next one then is the Hickson, and that's chromium problem out there, and that they were scared. I looked at my file the other day, and it was scheduled, but then we were busy with Sunshine Canyon, so it was set aside. And we probably want to take a look at that one.
There were several cases related to Hickson. Some of them have been completed. I don't know which of them are still active, but apparently there was a compliance with one of the cases. But the other, I think, is still going, the order for abatement.
Well, couldn't we get a status for our benefit of the report as to what's happening out there in that project site?
Well, let me take a look at the cases and see which of them might be appropriate for bringing back.
No,
okay?
Done.
Do you remember the case number on Hickson?
I'll go home and get it and take a look.
Okay.
Call you up.
Do I need this at home?
Which case do you have?
I haven't really gone through it, so I don't know.
More than likely not. But
What will I need?
what you need is rules and regulations which you can get on the website.
But don't we have that white?
That's
Yeah,
your
the
reference
folder.
manual.
Yeah.
You will need that also.
Yeah, the reference manual has rules and regulations,
No.
doesn't
It has the hearing board rules.
it? Yeah.
That was not mine, that was
These are
yours.
the rules and
What's
regulations.
that?
It fell out somewhere.
No, I know, it was.
You don't have to.
No,
Um,
Yeah, sorry.
yeah.
So the reference manual has our rules, the hearing board rules on procedure,
Yes.
and the district rules and regulations, which are on the website. And if you have the time, I can show you how to locate them back in the office.